Wednesday, February. We're going to move our meeting to February 23rd, which is the Wednesday. While we're on the subject of calendars, I'd also like to bring up, what happens is, today we have 8 new cases, and we have a handful of continued cases. The continued cases that are going to go forward tonight will probably, by all likelihood, take the bulk of the meeting. We're going to go to the February 23rd, and maybe there'll be 1 or 2 other large cases that will drop down and take more time. So in the interest of moving some of the cases that are on our calendar tonight, which we won't have to re-advertise for, I propose that on the 8th of February, which is a Tuesday, that we reserve the right to have an alternate meeting in the month of February so that we can clear our calendar of the current cases. Is that okay with you, Mr. Costa? Is that okay with you, Mr. Regan?
That's fine. What we should do, if you're going to have the meeting on the 8th, is just to go ahead and plan for that and continue the items that that don't get reached tonight to that date. And those that are available can go forward on the 8th, or then, if those that aren't available, can go to the regular meeting on the 23rd.
That's what I was proposing, so good. So is that good for everyone on the board, the 8th of February?
Yes.
Okay, so with that, we're going to go through and review the continued petitions and to see where they sit, get a disposition. Mr. Heaney, if you can read the first ones.
Petition of Atlantic Beach Suites 2 LLC by their attorney, David P. Martland. This is at 42 through 44 and 56 Wave Avenue.
Mr. Martland, are you in the room tonight? Are you on Zoom? Yep. Angela, you going to pick him up?
Mr. Chairman?
Yes, Mr. Martling, can you tell us where this petition stands?
Yes, I believe this had actually been continued to the February date.
Okay.
I think it's incorrectly on this calendar.
Do you think we'll hear it on February 23rd?
I don't think it would be heard on February 23rd. I spoke last month with Mr. Regan about the need for the matter to be re-advertised and re-notified. And I think he and I and Mr. Costa were going to discuss that.
Okay, do you think we can get a resolution?
But we can discuss that this week, and that would give us enough time to advertise and renotice by the 23rd if that was...
I got seven days to get this in the paper, so,
Okay, Mr. Martling,
many years you want to...
Why don't we, we'll chat with Mr. Martland tomorrow. We'll figure out what we need to do to get it re-advertised and renoticed and back in front of the board.
thank you, Mr. Martling. You heard all that, correct?
Yes, thank you.
Okay, next petition.
Petition of Sens Corporation owner and GD Middletown West Main Road 1 LLC. And this is at 0 West Main Road, and this is for both of variance and special use.
Mr. Regan, I know we talked about this one earlier today. Is this one Mr. Lynch's case?
I believe Mr. Lynch and Mr. Martland are both involved in that one. There is one remaining issue that the town engineer is reviewing with regard to the proposed utility easement. And I had a brief discussion with Mr. Martland on that earlier this week, and I'll be talking with Mr. Hall to see if we can get that resolved. But I think that's the last remaining issue to this one moving forward. So
we can continue it to February 23rd?
yes, if we do that,
Okay.
I think that should be ready to go.
We'll continue that one to February 23rd as well.
The next two are a petition from Benjamin J. Contessa, owner, and this is for both a special use and a variance, and this is at 183 Walcott, and according to my notes, this was already continued to the February meeting.
Okay. You're in agreement with that, Mr. Regan?
Yes, this is going back to the planning board with a revised plan. Was in front of the board earlier this month, so February 23rd would be the date.
Next one, Mr. Heaney.
Petition of Newport National Real Estate LLC owners by their attorney, Robert M. Silva, and this is at 425 Mitchell's Lane.
Good evening, Mr. Chairman. We just completed the planning board hearing last night. The matter was approved, but Mr. Wolanski is preparing the decision with the conditions that were attached to the approval. So we're not prepared to go ahead tonight, but I would suggest we would be by the February 8th date. And if we could continue it at that point, we would proceed with the petition for variance.
Okay, we'll continue to February 8th.
Hey, if you continue that to February 8th, you're going to hear the other cases first, though, is that correct?
Yeah, I'm going to put you at the end of the calendar on the 8th so we can hear the smaller cases, because otherwise,
The whole idea of the meeting.
what's happening is the cases that are coming off of continuances are just driving the small guys way out.
Well, in that case,
You want to go to the 23rd?
I would prefer the 23rd.
Thank you, Mr.
Because
Silva.
I've got
Why
a
I
whole
brought it
bunch.
up, because I wanted to make sure that,
Yeah.
that you
Thank
knew
you,
that
Mr.
in
Silverio.
advance.
Yeah, we've got a number of witnesses, so I wouldn't want to have them.
Let's do it on the 23rd,
sit here.
Mr. Silva.
23rd would be fine. Thank you.
Thank you. Next petition.
Petition of Frank and Elena Fetchner, owners, and Dan Kopczak, applicant, and this is at 576 Tuckerman Avenue.
Are you ready? All I need to know, are you ready to go forward tonight? Okay, so you'll be our first case once we get to the hearings.
Petition of Seamus Kirby, owner, by their attorney Jeremiah C. Lynch III. This is at 24 Walcott Avenue.
Mr. Chairman, Jay Lynch, we're ready to proceed. I plan on being there around 6:30, 7 o'clock tonight to move ahead.
Okay, thank you very much, Mr. Lynch.
Thank you.
You'll be our second hearing.
Thank you.
The next order of business is a summary petition. Summary petitions typically are those that have minimal release, less than 25% relief requested. We're going to read the petition out. We're going to ask if there's anyone here that would like to either speak, that's here to speak against the petition. If there are none, then we're going to vote as a block and just pass it. If there is somebody that's here and we're going to go to a full hearing, this will drop to the last hearing of the evening. So, Mr. Heaney, if you can read it.
Petition of Michael Pearson, owner, Michael Pearson and Michelle Pearson, applicant, for a variance from section 603 to construct a 12-foot by 26-foot deck resulting in a 17-foot 5-inch rear yard setback where 30 feet is required. Said real estate is located at 8 Winthrop Drive and further identified as Lot 11 on Tax Assessor's Plat 114.
Okay, is there anyone in the audience that would like to speak against the petition this evening? Is there anyone online, on Zoom? Please raise your hand.
No hands being raised.
Thank you, Angela. We're going to go ahead then and vote. Do I have a motion to accept the petition as presented?
I'll make the motion.
Motion made by Mr. Silveira. Do I have a second?
I'll second it.
Second by Judith Rosenthal. First and second. All those in favor?
Aye.
Aye.
Motion carries 5-0. Yes. Yeah, let's go through them. The next order of business, we're going to go through the new petitions and just find out who's here, ready to go forward this evening.
Petition of Kevin Gross, owner, and Jeffrey Moniz, applicant, and this is at 40 Willow Avenue.
Are you here this evening? Are you ready to go forward? You'll be our third petition tonight. Thank you.
Petition of M. DeHooten, Kapsky, Macumber, and D.N. Macumber owners at 1276 Green Hen Avenue.
Mr., you ready to go forward this evening? Okay, thank you. You'll be our fourth hearing.
Petition of Diane L. DeFazio and Edward A. Case owners, and Gerald Vento applicant, and this is at 2 Stimson Street.
Chairman J. Russell Jackson, Miller Scott Holbrook and Jackson. I represent abutters at 1 Stimson Street. We filed an objection. Request that this be continued. Martland, who represents the applicant, and he has no.
Okay, so we're going to continue to the 23rd? Okay.
Petition of David Green, owner, and Tommy Nasser applicant, and this is at 25 Brookdale Road.
Are you ready to go forward this evening? Thank you. You'll be our fifth petition.
Petition of William J. and Elizabeth M. Gill owners, represented by their attorney David P. Martland Esquire. This is at 1032 East Main Road.
Mr. Martland, are you ready to
Yes.
go?
We are ready to go forward on those 2 petitions, Mr. Chairman.
You'll be our sixth petition this evening?
Okay.
Petition of Kendall Tucker Homes owner by their attorney David P. Martland. This is at Walcott in Briarwood.
Mr.
We're ready to
Martland?
go forward on that matter as well, Mr. Chairman.
That'll be our seventh petition?
Okay.
Petition of Christopher DePero, owner, and this is at 15 Seascape Avenue.
Mr. DePere, are you ready to go forward? Thank you, everybody. You'll be our eighth petition. The next order of business, we're going to start with our first continued petition. If you can read the entire record for Frank and Ellen Fetchner.
Petition of Frank and Eleanor Fetner, owners, and Dan Kopsak, applicant, for a variance from sections 803, Article 8, to construct an additional level to the main building on the existing non-conforming footprint. The main building is non-conforming on the northwest corner, thus causing a 14-foot setback where 20 feet is required. Said real estate is located at 576 Tuckerman Avenue and further identified as Lot 117 on Tax Assessor's Plat 122.
Come on up. Raise your right hand, please. Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
Danielle Dufault, Adler, Pollock, and Sheehan, 49 Bellevue Ave.
I apologize, you didn't have to swear you in.
No worries.
My apology.
No worries.
These masks, I don't recognize people.
I'm sorry, what was that? Okay, sure, no worries. Dufault, D-U-F as in Frank, A-U-L-T as in Tom. Good evening, Mr. Chair, board members. Danielle Dufault from Adler, Pollock, and Sheehan, on behalf of the petitioners, the applicant, Dan Kopsak and Phoenix Building, for the owners of the property, Elena and Frank Fetchner. With us this evening, we have Frank Fetchner, who will be testifying, and our expert Ned Caswell, and my colleague John Russell from Adler, Pollock, and Sheehan as well. Mr. Chair, if it pleases the board, I'd like to, and you read into the record, the applicant and owners are seeking a side setback relief from the right side setback. It is a existing non-conforming setback relief, 14 where 20 is required, and we are requesting, that's the only relief in front of the board this evening. If it pleases the chair and the board, I'd like to begin with testimony from Frank Fetchner this evening.
Very good. Mr. Fetchner, raise your right hand, please. Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
That's my daughter, I'm sorry. Frank Fetchner, 576 Tuckerman Avenue, Middletown.
Okay.
Thank you. Mr. Fetchner, for the record, can you spell your last name, please?
F like in Frank, E-C-H-N-E-R.
And Mr. Fetchner, when did you and your wife purchase the subject property at 576 Tuckerman Avenue?
That was in late spring of 2014.
So you've owned the property for approximately 7 years, is that correct?
Correct.
And is the subject property your family's primary residence?
No, this is our second residence.
But do you have plans, to make the subject property a more permanent residence in the future?
We do actually, over the last 7.5 years, we spend more and more time in Middletown, and I expect that to continue.
And how much time do you spend now, currently, at 576 Tuckerman Ave?
So my wife spends all 3 summer months with our 3 kids. They basically move to Middletown, and I spend as much time as I can during the summer there. In addition, our kids are avid sailors, and the sailing season is from late March until late October. So that means that during this time, they're spent, in addition to the summer, virtually every weekend here. And then during the winter months, it's probably 1 to 2 weekends a month.
And do you host, in the summer months or on those weekends when we're staying at 576 Tuckerman Avenue, do you host family and friends and have people over?
We do.
And you heard the petition read that you're requesting the dimensional relief from the side setback, and that came about because of why? What are you proposing to do at the property?
So we would like to expand our living space by adding a 3rd level to the current 2-level dwelling on the existing footprint.
Okay, and part of that, adding the 3rd level, what are you doing, square footage, bedrooms? Can you explain a little bit more to the board?
Sure. I think our footprint is probably just in excess of 1,000 square feet. So we have 2,200 square feet, I think, currently as a living space. So we would love to expand it by another good 1,000 or 1,100 square feet. In order to do so, we have to eliminate 1 bedroom in order to get staircase access to the 3rd level. And so we are moving that 1 bedroom to the 3rd floor. And we also would like to add an additional bathroom as well as a family room to the 3rd floor.
And in adding that 3rd level, will it be going outside of the footprint of the existing dwelling, the single-family dwelling that's existing currently? Will that 3rd level be expanding outside of that?
No, it doesn't.
And were there any additional, what was the motivation in wanting to add this 3rd level to the existing dwelling?
Yeah, well, number one, we do spend more and more time in Middletown. Our kids are growing. We now have 2 teenagers, and they just ask for more space and for more privacy, and sometimes even good for Elena and myself to have a little bit of privacy from the kids. We just seem to need more space.
Your teenagers want some privacy, and you want some privacy from your teenagers.
Correct.
That's a fair ask for having a home, I think. Any additional motivations that for the reasons that you use your property? Any additional motivations for adding the third level?
No, it's really for our family.
Yeah, and any extended family that would be coming to stay or visit, or any other reasons for adding that space?
Yeah, I mean, our family usually comes for probably about 2 weeks a year, and we are currently used to kind of cram each other together. It's probably going to be a little bit more comfortable, but it's not that everybody's going to have their own bedroom.
Right,
Yeah,
right.
We're used to camping during this time a little bit, yeah.
And you're,
Without a tent.
right, and you have family, your elderly mother that might be coming to make a little bit more permanent home with you and Elena as well?
Yeah, unfortunately, she wasn't able to come for the last 2 years. She lives in Germany, but she used to come with my late father, and now that she's 81, she can't wait to actually spend more time with us. The travel easements from Germany have been relieved, and so she's going to join us and will spend more time with us. And she honestly has no interest in doing so in Worcester. She likes to come here to Middletown.
And when you refer to Worcester, you're referring to what is currently your primary residence?
That's correct.
And about the subject property, it's the address is 576 Tuckerman Avenue, but do you have frontage, meaning do you have a public street on both sides of, both on Tuckerman and Ashurst?
That's right.
And the frontage that you have, those amount of feet running along each one of those roads, on Tuckerman and on Ashurst, is there a difference in the length of how much road width you have there?
Yeah, the lot is almost like a trapezoid, right? So it's getting narrow towards Ashurst and is wider towards Tuckerman.
So, right, so it narrows a little bit more, I don't know, whatever you're looking at the top, but.
That's right.
Yeah, almost
towards
into
Ashurst.
like a triangle, because it is pretty severe, would you say?
It's quite narrow towards Ashurst.
Okay. And regarding this right side setback, and this non-conformance of the right side setback, was that present when you and Elena purchased the property in 2014?
It was.
And at that time, did you have a survey conducted of the property?
No,
Were you aware of the non-conformance at that time?
Well, so we did not have a survey conducted. We were aware that the garage was non-conforming, but honestly, we were not aware that the main dwelling was also non-conforming. At the time, that honestly didn't make a difference to us.
And were you required by the mortgage company or anyone to have a survey performed?
No.
Or did advise to have the survey performed? You were able to get title insurance for the property, correct?
Correct.
And are you aware of any other homes in your surrounding neighborhood on Tuckerman, Ashurst? You know, you're familiar, all too familiar now with what an abutters list, your surrounding abutters, that have third floors on their dwellings?
Absolutely, yeah.
Yeah. And while you might not know specific addresses, you are aware by, how do you know that? Just by?
Well, I mean, our immediate neighbor, Mr. Korbilak and Ms. Tabor, they actually just are still in the process of major new build of their property, and that is a 3-level property.
And you're referring to, if you're standing on Tuckerman looking at your home, you're referring to the neighbor to the right that
Correct.
is either referred to as 592 Tuckerman or 80 Ashurst, depending on mailing address or tax assessor's office. That's the one you're referring
Correct.
to?
Yes.
And are there other properties in the neighborhood that have third levels?
Yes. Like diagonally in the back of us, family Hellendrand, they have a 3-level property. And then honestly now probably, if anybody has been to Tuckerman recently, most of the buildings are 3-level.
Thank you. And are you asking and proposing this renovation, seeking any other variances besides the side setback relief as part of your petition?
No.
And as part of this renovation of adding the third levels, have you gone through several iterations of plans with your builder to try to make it the aesthetically pleasing and, try to conform to not have to go through any of these processes?
Yes, I mean, of course, we want to be proud of our house, and we are investing quite a bit of resources, so we want to make it as attractive and appealing as possible and as much in keeping with the neighborhood.
And did you reach out as part of getting ready to, knowing that you had to submit a petition for a variance because of the existing nonconformities, and before submitting plans to the building official, did you reach out to your neighbors and let them know about, or Elena, reach out to the neighbors to let them know what was going on and seek their input, or just give them the kind of heads up? Have you reached out to anybody?
Yeah, we did. We primarily talked to our abutters in the back of us because they are the ones that are really mostly impacted, which is on 71 Ashurst, family Hellendrunk, and on 81 Ashurst, with Chung.
And so, in constructing the third level, is this in any way an attempt to seek any type of financial gain by adding this third level to your home? Is it, you had testified earlier that it was so the teenagers can have some privacy and the adults can have some privacy, but the motivation, would you say the motivation is for those reasons or for financial gain reasons?
No, it's solely for use purpose. There's no other reason behind that project.
Thank you. So just a few more questions. So you mentioned some of your neighbors at 71 Ashurst and 81 Ashurst. Are you aware whether anyone in the audience, whether via Zoom or in the audience in person tonight, or is in attendance in support of your petition, or have submitted any letters in support of your petition?
I'm aware that Mr. Payson Fugit, who lives on 1 Kent Road, is in support of our petition. I'm also aware that Ingrid Chang, who lives on 81 Ashurst, is in support of this petition, as well as family Hellendrunk, who live on 71 Ashurst. They're also in support of that.
Thank you. Mr. Chair, it's my understanding, communicating with Ms. Marshall, that some of the letters in support made it to the board before the board was picked up their packets. And Mr. Fugit had submitted a supplemental letter. I do have copies of that letter that I would like to introduce as an exhibit to the board.
We'll mark it Exhibit A.
Thank you. And Mr. Fetchner, does this look like the letter that you had received a copy of from Mr. Fugit that we're submitting as Exhibit A?
It does.
Mr. Chair, it's my understanding that Mr. Fugit had, per his letter, my understanding per his letter, was that he had previously corresponded with the board back in July of 2021. So I would just like to make a note of that for the record. And if the board does not have that letter currently in their packet, would like the opportunity to submit it supplementally to the board. And the same with the letters from the supporters at 71 Ashurst and 81 Ashurst, Ms. Heldentrum and Mr. Olakowski, sorry.
We have both of those in the file already, so I think we're good. I don't see the 721 letter. I'm looking for it now.
And that was the initial letter from Mr. Fugit?
Yes, I'm looking for that. I'm sure it's here. Do we have that in the file, in the box?
Mr. Chairman, this might have came in late this afternoon, so we
No, I
said-
have that one, which is the same one she gave us today.
Yes.
I don't see she referenced the letter from 7/21, July of 21, and I don't see that in the file.
I submitted everything that came via email up to 6 o'clock.
So that was, Mr. Chair, if I may, in Mr. Fugit's letter, he references that he wrote a letter to the board, I believe, and you'll have to forgive me, we were retained in August of last year, but that he had submitted a letter to the board in July of 2021, I believe, so.
I think I just found it.
Okay.
So we have both letters. And we would have received that in our packets as well.
Excellent, thank you. So, Mr. Fetchner, other questions. So we talked about the letters of support that you've received from at least 3 of your neighbors, and have you received, or do you know of anyone that is either virtually or in the audience this evening that has expressed an objection to your petition or has, sent a letter to the board in objection? Are you aware of any of that?
I'm aware that yes, I am. In August, we received an email from Attorney Jackson, who is representing our immediate neighbors, Mr. Korbelak and Ms. Tabor, who were objecting to the petition, and that objection would have been overcome if he would have basically followed 5 demands that were made, including a view easement, including movement of the lot line, including removal of the tree, including never engaging in short-term rentals, and then there was 1/5 demand, which I don't recall right now.
If you recall, it had something to do with capping the maximum height of any of the trees that would be planted on that common border between your property and Mr. Kovalak's property?
I think so. I'm not 100% sure. That was back in August.
Yeah. And when you say the list of these 5 demands, did the email correspondence say that if you were to agree to those 5 demands that they listed, that they would withdraw their objection to your petition?
That was my understanding from the email.
And have you had any subsequent conversations, or do you have any intentions? Let's talk about just briefly. Do you and Elena have any intentions of having short-term rentals at your property?
We do not. We had, over the last 7.5 years, I think we rented our house for a total of 6 weeks. The last time was almost 4 years ago, and we have no intention of doing that again.
But you understand that you are allowed to do that by right as long as you apply for a permit with the town, correct?
Correct.
And you discussed the condition about agreeing to this new lot line and a new property line. And what is that, if you know the details of that?
I think that there's a bigger story behind that because some trees were removed by our neighbors, which
Mr. Chairman, I'm going to object. The dispute regarding the lot line and trees, to an extent at this point, is irrelevant regarding the relief that's being requested by the applicant.
Thank you, Mr. Jackson, noted.
Fine. And that's fine. We'll move on.
Can I ask one question, because I'm kind of scratching my head? You say the lot is not, it's a non-conforming use currently?
No, I'm sorry. If I did, I misspoke. It's an existing nonconformance. The existing dwelling is in the setback, is
Right.
currently located in the setback and has been since,
So we're here tonight for a variance?
correct.
Okay.
From the right side setback.
Right, but it's not a non-conforming use, it's because it's in
Not
the
a
setback.
non-conforming use. It is,
But in your petition to the town, you referenced section 803, which is extensions and alterations to a non-conforming use. I think we're in a variance, right, Mr. Costa?
it's,
Oh, let me just get this clear.
803 is a section, I'll get it right here for you, of non-conforming, expansion, alteration of a non-conforming structure.
yeah.
Right. But are you non-conforming if you're in the setbacks, or,
It's existing non-conforming.
right? So if we follow the code precisely, what's missing from their packet, and excuse me, I don't mean to cut you off, but if we've got to re-advertise it, and I will look to Ms. Desautels to give me clearance. 803 clearly says that we need a special use permit as well.
Yes.
Am I right on the?
Yeah, it states that if a non-conforming structure other than a sign can be extended or enlarged in any lawful manner without increasing the extent of the nonconformity, then any extension or enlargement thereof shall only be permitted in accordance with the district dimensional regulations. Otherwise, variance for relief from the zoning board shall be.
So they don't need the
No,
special use
so
because it's within
the way
the,
it's reading, it's not reading that it requires a special use.
I just wanted to be clear on that.
Right.
Sorry, I just wanted to make sure that we didn't go on too far.
No, so just so we're clear, the reason, and it's our understanding, I just want to be clear that we're all on the same page. The reason we're here this evening is because the addition of the third level to the current structure, because it's a non-conforming structure,
Right.
the expansion triggers the reason to request the variance.
Right.
And we don't slip into the non-conforming use special permit and the extra.
Yep, I understand.
Okay. So I just have a few follow-up questions, and then we'll be done with this one. Mr. Fetchner, just to wrap up, you testified that your motivation is to just be able to enjoy the use of your single-family dwelling that you're currently enjoying, but you need this additional room. Is that correct?
Correct.
And this one request for a variance it's just this one that you're requesting and nothing additional at this time?
Correct.
And this is, and this exists currently? The setback, the current dwelling is in the setback?
That is correct.
And you purchased a property, this was like this in 2014 when you purchased it?
It was.
Mr. Chair, I don't have any further questions for Mr. Fetchner at this time.
Okay.
I'd like to bring up our Mr. Ned Caswell.
Have the opportunity to cross-examine the witness.
Absolutely. Good.
Chris, I don't know if it's possible to pull up the site plan that was with the application on the screen.
I don't have access to that, Mr. Russell.
Mr. Fetchner, you testified that when you bought the property, thanks.
You testified that when you bought the property, you were not aware of the fact that the existing residence encroaches into the side setback. Is that correct?
That's correct.
Okay. Now, were you aware, aside from that encroachment, of other nonconformities with your property?
I was aware of the fact that the garage is non-conforming.
Okay. And you've also got a shed that sits on the rear property line, which encroaches into a setback. Is that right?
I'm not aware of that the shed is that's a temporary structure.
Okay. It's depicted on the site plan and survey that you provided as part of your application, correct?
I have to defer I'm not sure.
Okay. Now, your aside from the structure where you intend to expand a full 3 floors, your garage encroaches into a side setback as well. Is that right?
I know that the garage is encroaching upon the frontage to Ashurst.
Okay. And it's closer than 20 feet to your south property line, correct?
It is. I think so, yeah. Mhm.
In addition to those dimensional nonconformities, there was also, when you purchased this property, it had a pool. Is that correct?
Yes.
And the pool's in your front yard.
Yes.
And the pool is, in fact, closer to the front property line facing Tuckerman than 40 feet. Isn't that right?
I don't know. It was there. I don't know.
So, fair to say that you purchased a property with a number of dimensional nonconformities, correct? Some of which you were aware of, some of which you weren't.
That's a fact.
Okay. Now, in 2016, you came before this board to seek relief to encroach into the north side setback, just like you're trying to do this evening, correct?
This evening we want to go up.
Let me rephrase that question. In 2016, you came to this board to ask relief to build a deck which would encroach into your north side setback. Is that right?
Correct.
Okay. And obviously, at the time, part of what you presented to the board was a statement or a representation that that was the least relief necessary for the reasonable use of your property. Is that right?
I'm sorry, I don't know what that exactly means, but can you rephrase the question?
Well, that's one of the standards that you have to meet in order to get a dimensional variance. And obviously, you made that representation when you asked for a dimensional variance in 2016, correct?
If that's, yeah. Mhm.
Okay. So, at least at that time, you became much more familiar with the zoning process and what dimensional nonconformities existed on your property. Is that fair to say?
Yes.
All right. So now you're back this evening seeking permission to encroach into that north side setback again, right?
We want to add a third level, yeah.
Now, your lot is a full 20, it's in excess of 20,000 square feet, isn't it?
I think so, yeah.
So although the existing structure encroaches into some setbacks, the lot itself is conforming as far as land area, right?
Yes.
So since there's sufficient land area, what other options did you explore in coming up with an expansion plan which wouldn't require you to encroach further into setbacks?
We didn't explore any other options.
So the plan you chose was just to add a floor to the existing structure, correct?
To make it as least intrusive and the most economical as possible. Yeah.
So, but given the land area you have, there was an opportunity to potentially expand above either the existing garage or somewhere along the south portion of your lot, which wouldn't result into a further encroachment into any setbacks?
We didn't even think about this other than adding 1,000 square feet to our existing structure.
So, Mr. Fechner, one of the other things you testified to was that this is for personal use and that your family uses the property during the summer months. Is that right?
Correct.
Chairman, I have an exhibit, if I could present it.
We're going to label this Exhibit B.
Russell.
Oh, sorry. So, Mr. Fechner, I've presented to you what's been identified as Exhibit B, and it's a listing with Gustav White Sotheby's Realty for your property. And it indicates that it's available for summer weekly rental at $12,000 a week, commencing July 1st, 2021. Do you recognize that?
Honestly, I would have to refer to my wife Elena because she is the one that used to do the short-term rental. In general, over the last 7.5 years, we rented our house for a total of 6 weeks. And the last one was about 3.5 years ago. And as I mentioned, we have no intention of doing that again because it was honestly, it's not worth it. But how this comes all about, I cannot answer for you. Maybe Elena can tell us.
Are you saying that you didn't list it? You don't know?
I just, we're looking at this, whatever this exhibit is. It's not date stamped when it was printed. Available starting July 1st, 2021. We're now in almost February of 2022. We don't know if this has been removed or is still current. Without more facts, I'm not really sure what this is indicative of. If you test...
It's a pretty simple question. Did you list the property for rent in 2021? There's been a representation that they occupy the premises all summer, that they're not doing short-term rentals. My client will be testifying as regards to the history of short-term rentals that they've dealt with, and this is part of the concern about this application is that the expansion of the property is going to be utilized eventually again for short-term rentals.
I would say, Mr. Chair, Mr. Fetchner testified that they have in the past rented the property out, said that they did for a total of approximately 6 weeks. He also further testified that they have no intention in the future to do so. And I followed up in asking him, you understand that's your right to do so, zoning ordinances, and if you needed to, which Mr. Fetchner said, yes. I think we're clear.
Yeah,
Move on.
I think we can move on, Mr. Jackson.
Sure. Mr. Fechner, how many bedrooms are in the house right now?
4.
All right, so this is a second home right now.
Correct.
So to be clear, a 4-bedroom, 2,000 square foot house is insufficient to serve as a second home for your family. Is that what your testimony is?
Well, we would love to have a little bit more space.
Right, it'd be nice, right?
Would be nice, yes.
And if you couldn't, you still have a nice 4-bedroom, 2,000 square foot home with a deck facing southeast to look at the ocean, right?
Yeah, honestly, the additional aspect is that my mom will spend more time with us, And being 81, that is, she needs a little bit of her own space, and we at the same time want to be able to use the house too. In addition, I don't know whether you have kids, but teenagers, they just need more space. And I think that would really allow us to use our property to its fullest potential.
So when this is done, what's the total square footage that you're going to have?
Then maybe it's going to be 3,200 square feet.
Now, Mr. Chairman, I know that you want me to sort of move on from the rental aspect, but I just have one follow-up question. So, Mr. Fetchner, obviously a house that has over 3,000 square feet and more than 4 bedrooms is going to net greater rents in the summer on a weekly basis than what you have right now. Is that correct?
Mr. Jackson, he's already attested that they're not going to rent going forward, so I appreciate your comment.
I'm all set, Mr. Chairman. Thank you.
Thank you, Mr. Jackson. Sure.
Mr. Fetchner, just a few follow-up questions on some of the questions that were posed to you by Attorney Jackson. Are you, when you spoke or asked about the previous variance that you applied to this board for about the deck that Attorney Jackson referenced, at that time, were you represented by counsel, or did you apply for it on your own?
We did it by ourselves.
And at that time, when you first applied to the board, did the board grant that petition immediately, or did you have to continue the matter because they asked you to redesign it?
Yes, it was struck down. It was not approved, and we had to redesign.
So you worked with the
deck.
board and came back and you presented the board with a new plan?
Correct.
And it was still within the setback?
Yes.
But it was a little less relief necessary to build what is currently the deck at the property, correct?
That's correct.
And at that time of the request for a variance for that deck, when you came back, right, and the board heard it and, correct me if I'm wrong, approved it unanimously, is that correct? Mm-hmm. Did the abutter objector who is objecting this evening, did they object to that variance request?
No.
No further questions.
Thank you.
If I may bring Mr. Caswell up to testify, please.
Absolutely.
Thank you, Mr. Fetchner.
Please raise your right hand. Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
My name is Ned Caswell, and my address is 140 Point Judith Road, Narragansett, Rhode Island.
Mr. Chair, at this time, I would like the board to recognize Mr. Caswell as the petitioner's expert in land use. I believe that, I know that Mr. Caswell's report, which includes his CV, was submitted to Ms. Marshall and Mr. Costner yesterday. I fear that it didn't make it into your packets, but we are prepared to submit it to the board now as an exhibit, if the board will accept it.
Yes, I'll accept it and mark it Exhibit C. We have it in the packet as well, I believe. But if you can give me one for the record, that would be great. I don't have it in here. I didn't have it in it's not in here.
I have it? Okay.
So we're going to mark that Exhibit C.
Thank you.
And we will accept Mr. Caswell as an expert based on his CV and his certifications.
Thank you very much.
Thank you, Mr. Caswell.
Thank you, Mr. Chair. Mr. Caswell, can you please state your name again for the record and spell your full name for the record? We refer to you as Ned, and spell your last name, please.
My full name is Edward. My last name is Caswell, Caswell.
And as you heard, the board has recognized you as the applicant and owner's expert this evening and accepted your report that we previously submitted as an exhibit in the Fetner's petition that is currently in front of the board. Could you briefly explain some of what you did in crafting your report regarding the Fetner's petition?
Basically, I did an area search, traveled the neighborhood. I walked the subject property, taking photos, looking at the neighbors on all three sides, and then roamed again the neighborhood to take photos of similar properties that exist or presently exist, basically that have the third floor additions or even new construction, which is in the package.
And Mr. Caswell, are you aware, when was the subject property at 576 Tuckerman Ave, when was the property built?
Oh, gee, I'd have to go back.
I knew I'd get you. Is it true that in your report you had listed that the subject property was built approximately in...
By town records, it was built in 1950.
Okay. And which you also listed in your report was similar to the dwelling on lot 118, which abuts the subject property to the left. If you're standing and looking at the subject property from Tuckerman Ave, that property was built in 1952, is that correct?
That's correct.
And the lot 592 Tuckerman to the right of the Fetchner's property was built in approximately 1948?
Yes.
Now, about the 592 Tuckerman lot, that lot, what is the lot number designation given to that? Is that lot 117?
Let me look at my report here.
If I can refer you to your report on page 2, second full paragraph.
That would be, whoops, sorry about that.
No, you're
That would be 118, lot 118, yes,
So-
correct.
Right, so to the left of the Fetchner's property, that's 118. To the right of the Fetchner's property, is that lot 117?
That's correct.
And the Fetchner's property is designated as lot 117A?
That's correct.
And what would that suggest to you, Mr. Caswell?
Well, when I first looked at this, it appeared that back when they did the original subdivision, that 117 was a larger lot, and the lot to the left, to the south, is 118. So my first thought was that the property probably at some point had been subdivided, and they couldn't call it 119 or 120, so they called it 117A.
So the subdivision, the subscript of a designation with an A may suggest that it was additionally one lot subdivided into two.
That's correct.
Now, about the subject lot, this 117A, the Fetchner's property, also referred to as 576 Tuckerman Avenue, how would you describe the shape of that lot?
Well, it's kind of a rectangular trapezoid, I would say.
So, right, it's a hybrid between a rectangle, triangle, would you say that because that the lot abuts both Tuckerman Ave and Ashurst Ave, is that correct?
That's correct.
Now, on Tuckerman Ave, per the survey and I believe per the town map, the total width on Tuckerman is 130 feet, correct?
Correct.
And on Ashurst, it's 80 feet?
80 feet, I believe, yes.
So it narrows significantly as the property moves to the west towards Ashurst, is that correct?
Correct.
So would you say that is, what type of lot? Would you say that is a traditionally shaped, have you seen that before? How would you describe it? Besides the
Yeah.
shape.
I've seen shaped lots like this before, especially where you have two roads coming together, Tuckerman and Ashwitz. Then something has got to give somewheres, and it's going to be in the width of one lot or the other, or one end or the other.
And it
Yes,
forms, would you say, some type of a regular shaped lot?
correct.
And when you talked about how you came about preparing your report, and you talked about walking the neighborhood and looking at the properties, and
Correct.
I don't know if you said take pictures, but
I did.
Okay. And
From the street.
from the street, that's good, you should go on their property. From the street, and when you did that, did you observe any other properties in the neighborhood that had third levels on them?
Yes, I did, several, and that's in the report.
And to your knowledge, in this is an R20 zoning district?
20.
And in this district, in an R20 district, per the Middletown Comprehensive Plan, are single-family dwellings an allowed use and something that is in accordance with the comprehensive plan?
Yes.
Now, when you were, in your expert opinion, and based on your study of this property and your knowledge of the surrounding properties, would you say that the hardship that the applicant seeks relief from, this side yard setback, 14, it's only 14 now, where 20 is required, would you say that it's due to the unique characteristics of Lot 117A, or rather than just the general characteristics of the neighborhood?
No, it's because of the odd shape of the property itself.
And would you say that the hardship you had said that this was built in approximately 1958, I believe?
I believe it was, yeah.
And now, would you say that this, what we just talked about, the current dwelling being located in the side yard setback, the right side yard setback, was this something that the applicant caused? Or was this here prior to when the applicant purchased it?
This was here when he bought
Right,
it,
because
he and she.
right, I believe you heard previously that the Fetchners, and you know this by looking through the records, that they purchased it in 2014.
That's correct.
And when they purchased it, the current dwelling was built in 1958.
That's correct.
So it's not something the applicant caused. They didn't cause the structure to be built within the setback. And would you say that requesting, if the board were to grant the variance to the Fetchners, would this in any way alter the characteristic, the general character of the surrounding neighborhood? Would it be detrimental to the character of the surrounding neighborhood, in your expert opinion?
It would not. Basically, it's high, it's above, it conforms to the neighborhood and what's happened over the years in the surrounding properties. And basically from the roadside, it blends. I've seen the drawings of the plans, and I believe you're going to bring the builder up later. But it does conform to the neighborhood and to the size. In other words, it's not overbuilt. As a matter of fact, it's still one of the smallest homes in the area. So, yes, I'd say it does conform.
Does it conform to the maximum height requirement or of the zoning ordinances?
I believe it does, yes.
Being 35 feet.
Feet.
And as we're aware from the plans, it's not proposed to be above 35 feet.
Right, that's not in the application.
Correct. And would you, I know that it's included in your report, but would you say that the proposed addition to the third level, would this in any way adversely affect it's outside of the buildable scale of the surrounding properties? The other homes, you testified earlier, there's other homes with third levels, right?
Definitely.
And would this be outside the scale of those other homes in the surrounding area?
This would be smaller than the majority of the homes in the area.
And this use, the use as a single-family dwelling, the addition of the third level would just allow the Fetchners to continue to use their home as a single-family dwelling? It's the least release necessary? Is that, in your expert's opinion, would you agree?
I have, my son just rebuilt his house. It did exactly the same thing because we have 5 grandchildren and they're all 6 foot plus. So the house got very small and they put an addition on it.
Oh,
So I agree with that statement.
That's your expert opinion.
As an expert opinion.
Yeah. Teenagers need more room.
They sure do.
Right. Mr. Chair, that concludes my questions for Mr. Caswell.
Mr. Caswell, so it's your expert opinion that the addition of the third floor bedroom isn't an expansion of use because the bedroom exists on the second floor now, so they're just moving it up, correct? I'm trying to get my arms around this.
Well, it is an addition of space, and it's going to be family area plus a bedroom, so they're not doing away with the other bedrooms down below. So would you call going from 4 bedrooms to 5 an expansion of use? In my opinion, no, because it's a single-family home. It's not like, and the mother is going to come, but I don't believe it's going to be a mother-in-law apartment. There's
No,
no
I
stove
didn't gather
or
that.
anything like that.
And so then my last question is, what about the deck that's on top of the third floor? Does that represent an expansion of use? And in your walk around the neighborhood, I looked at the pictures, I didn't see any other third floor decks, because that deck is built, the handrail is probably right at 34.6.
Is it that close?
So that means that anyone's head's above the height restriction that's up there.
That's
It's a
something-
question, because that, in my lay opinion, would be an expansion of use, right?
If I could, I just want to clarify, if I could, Mr. Chair, your questions. So back to what we were discussing previously about what's before the board is the dimensional variance because of the existing structure being located within the setback. So we're not in front of the board for any type of a use variance or an expansion of use. It's because of the existing nonconformity of the structure, that it is located within the setback.
Right, but the relief is more than just the third floor. The relief is the third floor and the deck that goes on top of it.
And, right, but not being
So-
an expansion of the use. It's still part of a single-family dwelling, which is allowed by right as a use in an R20. That, I just want to make, I know it wasn't phrased as a question, but I just want to make sure that I'm tracking your question, so we're providing accurate evidence. Oh, sorry.
Mr. Chair, if I may, John Russell from Adler Pollock. The client has decided not to.
Yeah, you need to speak into a microphone so the stenographer and we can hear.
Good evening, John Russell, Adler Pollock. If I may, Mr. Chairman, members of the board, my client's builder just informed me that they've removed the idea to put on the widow's walk, so it is no longer an issue. Just
Okay.
wanted to present that for the
That
board.
answers my question.
Okay.
Thank you.
Sorry to interrupt.
No, no worries, thank you.
I'm happy that happened because I don't think I could have answered that question. That was more of a technical question than.
Okay, thank you. That was the only question I had. Does anyone have any questions of Mr. Caswell? Mr. Jackson?
I just have a few questions, please. Thank you. If the board could just bear with me, because this is the first time I've seen this report as well. So, Mr. Caswell, obviously in reviewing this, being accepted as an expert, you're familiar with the Middletown zoning code, you're familiar with the Middletown comprehensive plan, correct?
Yes.
And you're also familiar with essentially general underlying principles of planning and zoning. Is that fair to say?
Yes.
So would you agree with me that a general underlying principle is that when you have a non-conforming property, that generally the idea of planning and zoning is to bring it into conformance?
I was on the South Kingstown Planning Board for 10 years, and these issues came up back long ago. So these issues are nothing that's new. Times change, families grow. People don't want to sell their homes and go buy another one because they like a location or they like the home that they're in. So naturally, they go and expand. And having zoning coming in 1950s, when these houses were built, or this house was built, you know, there's certainly been some changes in the zoning rules and regulations that maybe do not fall within the acceptance of an owner with a growing family. So other than that, I don't know how to answer that question. Just because times change.
Sure. Well, let me sort of look at it from a different angle. In terms of this particular property, I think by virtue of the plans that were submitted and Mr. Fechner's testimony, it's clear that there exist a number of dimensional nonconformities with this property, correct?
That was prior to, yes.
Right, including the deck which encroaches into the north setback, which was created by the Fechners, correct?
I'm not aware of, I don't know that history. I know it was there. I've heard the chat about that.
That's not something you examined as part of your...
I did. So the deck was there, and I assumed that it was approved. I'm assuming that whoever built it had to go get a building permit, but I did not check the building records to see that they did get a building permit.
Right, but again, that nonconformity was created by the Fechners, correct?
Yes.
So much of your testimony had to do with other properties in the area that were also 3 stories, right?
That's correct.
Now, as part of your analysis, did you look at those properties that had 3 stories to make a determination of how many of those encroached into setbacks?
No, I did not. Some were small lots, some were larger lots.
And you certainly, by not doing that, you didn't make any inquiry as to how many of those received zoning relief to encroach into setbacks.
Led to what?
So by not knowing how many of those properties actually encroach into setbacks in the neighborhood, which have 3 stories, you certainly don't have any idea how many needed zoning relief to build 3 full stories into a setback.
I have faith in the board.
Now, as part of your analysis of this proposal, I would assume you gave an eye as to all the relief that was necessary in order for the Fechners to build the addition consistent with what they've proposed. Is that fair to say?
Yes, that was part of the conversation.
Now, is it your opinion that there are no other available options for the Fechners to expand their livable space?
I'm looking at this as being the least amount of relief because if there were expansion on the south side of the building, that might have a height that might affect the neighbors to the rear much more than what this addition is going to affect any of the neighbors.
Now, you included as part of your report the survey that was submitted with the application.
Correct.
Correct. Okay. And obviously, you can see depicted adjacent to the front of the residence is a very large deck that we've already discussed, correct?
Correct.
Now, if the Fetners were interested in expanding the livable square footage, they could abandon the use of that deck, which encroaches into the setback, and expand forward a bit to increase the livable square footage for their residents. Is that fair to say?
I was not there to discuss that issue. The deck was there, the deck is used. Obviously, it was approved here by the building board, and I'm not sure if they went to zoning for that exception or not, but it was granted. I'm assuming it's legal,
Yeah, okay.
so therefore I did
So
not.
my point being that, but for the existence of the deck which they created, there may be other options to expand the livable square footage other than going 3 stories up in the setback.
That was not part of my discussion with the owners.
Okay. Your analysis of the floor plan indicated that you're looking at 5 bedrooms plus a family room, which would be on the 3rd floor.
Correct.
So I'd like you to provide the basis. If you've indicated that, in your opinion, that not granting this relief would be more than a mere inconvenience, is that correct?
Correct.
I'm trying to understand how not providing a full 3rd floor, which requires setback relief, is more than a mere inconvenience when this property already is a 4-bedroom house with 2,000 square feet of livable square footage, with an accessory pool house structure, with a pool, with a garage. I'm trying to get my mind around what the hardship is and why it's more than a mere inconvenience.
Well, if in other words, your last statement, if you're thinking, and I think it was mentioned before, that the expansion could go out into the garage, or it could go into the shed, and I don't believe the zoning is going to allow 2 families. So everything has to be retained within the structure that's there by itself. And when you've got a family and you've got, growing children, and your mom wants to come live with you, then this is a perfect situation without having to go to the expansion of the total building footprint by itself. This is still within the same footprint.
Last question. Did you visit the property as part of your...
I did.
And did you examine, for instance, do you know what the uses are being made of for instance, the pool house?
I don't. This is in the middle of the winter, and
All right.
I
I
saw
guess
what
my
I thought
question
was
is the pool house livable square footage in there, or is it just simply storage area?
As far as I know, it's storage area.
Okay. Any other questions?
Thank you, Mr. Jackson. Absolutely.
Mr. Caswell, Attorney Jackson had asked you to opine about, as an expert, you studied the Middletown, the zoning ordinances and the comprehensive plan, and he had asked you, is it your experience, in your experience, isn't one of the general underlying principles to bring a non-conforming structure, or I'm not sure if you meant structure and use or whatever, into conformance? You recall that he asked you that question?
Not word for word, no.
But something to that effect about bringing something that's non-conforming into conformance. He asked you
Is
if
the goal,
if that was the goal.
if possible.
Yeah, and so you remember him asking you that question,
Correct.
And you're aware, specifically to the Fetchner's petition, that they are petitioning based on the Middletown zoning ordinances under the specific ordinance, which is, give me a second, Section 803F, which allows the applicant to petition the zoning board, which the applicant's doing now, if they have a non-conforming structure and they want to expand or add or change or move or alter that non-conforming structure, it requires them to, I'm sorry, it was not F, I apologize, G, that they need to come before the board and petition if they wanted to make any alterations to that structure. Is that correct?
That's normal with most zoning ordinances,
So-
yes, and comprehensive plans.
So in compliance with these zoning ordinances, there is an avenue for which owners of non-conforming structures can alter those structures, and they are not required to bring them into conformance, meaning knock them down. Is that correct?
That's correct.
And I asked you previously, the Middletown Comprehensive Plan for R20 zoning districts is a single-family dwelling in accordance with the Middletown Comprehensive Plan and medium-density residential neighborhoods.
I would assume yes.
And this is an R20 zone. And single-family dwellings, which is what the Fetchners own, are allowed by right. Is that correct?
That's correct.
And you you were also asked by Attorney Jackson about the deck and the variance that the Fetchners sought. And you are aware that the deck exists, right?
Correct.
But the deck is not we're not asking anything about the deck, correct? The Fetchners aren't building on top of the deck, correct?
No, they're not, that's correct.
We're not expanding any into the setback further for either the deck, which has been decided by the board, is that correct?
That's correct.
And the variance that is currently in front of the board is relief sought for the dwelling, right? The
The
single-family
dwelling
dwelling,
itself, yeah.
just to go straight up on top of it, right? We're not, are we
On top of
expanding the foot,
building.
right?
We're not expanding the footprint by coming in with an application to enclose the deck and make that into a bedroom.
Right. We're not building on top of the deck.
That's correct.
We're building on top of the existing dwelling,
Correct.
straight up,
Straight up.
not any farther into the 14 feet that's currently existing, correct?
By looking at the plans, I did not see that that was so, it was not extended into any other space other than
Staying within the current footprint
the
of the
footprint.
dwelling, correct?
The footprint is built, this is built on top of the footprint, not extending over the footprint. Correct.
Thank you. Mr. Chair, no further questions for Mr. Caswell. I would at this time, I just want to clarify, when we were discussing, and my colleague, Mr. Russell, had come up about the deck. And I think it's really important because I, again, want to make sure we're talking all about the same things and not changing the application too quickly. When you referred to, my colleagues referred to a widow's walk, and we were talking about a deck. And
Your partner and I were talking about the same thing.
okay, and you were talking about on the little deck that's coming out off the third floor, not anything other than
What I was
that.
talking about.
And your concerns about the deck, because I think the client may have been thinking it was something else. So I just want to, if the deck, the chair's concerns with the deck, if you could articulate that, I want to make sure that the client understands what your concerns were before we just quickly said we don't want it.
I think it impacts the neighborhood. I think my question to your expert witness was in your tour, and I know the answer because I looked at the photographs. How many other properties had widow walks or decks located above the third floor? And that is an expansion. That's significant to have a public space above the house. Even though it's built, the handrail's at 34.6, it still creates it can be a nuisance because it affects people's privacies. It's just something to consider as you're looking at the plan.
Sure.
I think we could use some clarity.
Yeah.
There's a deck on the third floor off of what looks like maybe a master bedroom or something like that, and then there's also a rooftop deck. I believe your testimony was that the rooftop deck was going to be removed. Is that correct?
May I have could I have just a like 20 seconds with my client, please? You're all set.
Okay, thank you. Thank you.
Well, there's this deck, because she's saying she don't want to give up that one.
Yeah, I'm talking about this one.
Exactly.
Yeah, I'm talking about the rooftop.
It's labeled the Widow's Watch on slide 3.
Talking about that.
Thank you, Mr. Chair. Mr. Curtin, thank you for that clarity, because that's what I was confused about, which, well, I think we had to get on the same page. So, the Widow's Walk
That's
on the
what we were
very
talking
top.
about.
Right. So, as the plans are now, submitted to the board, the small deck coming off of the addition on the third floor, the one that is above the deck on the second, that's not what we're talking about.
That's not what we're talking about.
Now we're talking about the Widow's Walk on the top. I will say this, we're aware of the maximum height requirement of 35 feet. And as you pointed out, the railing height, I believe, is at 34 and
6 inches.
6 inches. I believe that there are other Widow's Walk, and maybe Mr. Costa can speak to this, because I know he's reviewed plans for, there's a Widow's Walk at 592 as part of that new construction. So what we would ask respectfully is whatever the height for a Widow's Walk, based on the maximum height requirement in an R20 zone, would be applied uniformly. And in accordance with the maximum height, we're not asking for any more or any less. And we, of course, the client doesn't want to have to forego that. While there may not be, well, maybe only one person in the neighborhood now, currently, that has a Widow's Walk, the abutter directly to the right. We're not asking for more than we're privy to, but we wouldn't want to have to nix it all together. So if you could, I mean, if there's a condition that the board would consider, but we would just want the ability to have
I'm going to
that.
base my decision strictly on the code, so it's going to come down to that magic phrase, the least relief necessary. And so that's up to you to prove that it's the least relief necessary, and it's up to Mr. Jackson to prove that it's not. And then we all have our opinions up here that we're going to vote. So I respect
Right.
your decision, and we'll just take that under advisement when we debate.
And the least relief necessary as to the setback of the,
In general, what's the least relief necessary for the full enjoyment of the property?
understood, yep, understood. Okay,
You know,
thank
so it's, what I hear from you right now is your clients feel that the Widow's Walk is the least relief necessary.
Understood, and
so-
taking it all into,
So
understood.
I'm just going to put it all in the decision tree, and that's how we'll deal with it.
And if the client were to, if that is something with the Widow's Walk and being in the category of least relief necessary,
We don't need to debate this now. I mean, you've made your point. We've got
Yeah.
it. We can take it from here.
understood. Okay, thank you. At this time, Mr. Chair, I have no further witnesses at this time.
Mr. Jackson?
Thank you, Mr. Chairman. If I could, we've got two witnesses. I'm going to ask my client, Elizabeth Tabor Kobalak, to testify, and our real estate expert, James Houle. In the interest of having Ms. Kobalak testify quickly, she has written testimony that we'd like to submit into the record. She's going to read it. There are a number of pages. That's only because there are some photographs that illustrate and assist her with her testimony. So if I may distribute this to the board, and then, again, in the interest of moving it quickly, I'll just let Ms. Kobalak provide her testimony to the board.
We're going to mark that Exhibit D.
Thank you.
Good evening, Board.
Could you please raise your right hand?
Oh, sure.
Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
Elizabeth Tabor, 592 Tuckerman Avenue.
Okay, go ahead, thank you.
Sure, Elizabeth Tabor, T as in Tom, A. Oh, Kobalak, it's not my last name, but it's my husband's last name. Sure, sorry, K-O-B as in boy, Y-L-A-K. So why we are here tonight? My husband Joe and I are here tonight to protect our right to quiet enjoyment for our family and our forever home. Our son Charlie is autistic and sensitive to noise. He does not drive, but he stays active biking and taking nature walks. When he finishes school in Michigan, I look forward to expanding his programming skills and us working together. My husband and I both work exclusively from home, like so many do now, hosting conference calls when ambient noise distracts us as well. We needed lots of parking for my large local family. With no on-street parking available and parking on lawns illegal, we knew we needed to accommodate extra vehicles. On a gravel-covered, dead-end street, we bought our perfect property for this specific reason, and I hope for generations my family will enjoy it. Who we are, my family has lived here for generations, and I have family residing in all three communities on the island. My mother was a real estate broker, and my family owned many rental properties and actively managed them when we grew up. I too am a real estate broker. I've helped my siblings purchase multiple properties on the island, as well as many other people. I also support our neighbors' right to build anything that's within their rights, even when I don't like it. Our objection, pardon me, as year-round residents building a forever home, our next-door neighbors, the Fetchners, non-conforming pool and extensive outdoor entertaining space in their front yard and southern setback created a noise nuisance for us that was so severe we abandoned our plans to renovate our home on Tuckerman. In 2016, before we moved in, we accommodated the Fetchners' last deck variance that created an outdoor entertaining and dining space further west and deeper into our common border. Despite problems with short-term renters, we never reported the Fetchners to the authorities, and we continued striving for a good relationship, even allowing concrete trucks to renovate their pool area and create a ton of noise and disruption for us on our property. Additionally, the Fetchners refused to make any landscaping changes to tame overgrowth invading onto our property. Instead, Joe, Charlie, and I moved into the carriage house after Charlie refused to stay in the main house any longer due to the noise and disruption from next door. Joe and I doubled our budget to build spaces higher and further west from the pool area to protect our quiet enjoyment. We did it all by right within zoning rules, and we have shared plans, and worked with all of our neighbors throughout the planning process to protect our neighbors' privacy and collaboratively address any concerns they had. And in fact, I still don't have an actual plan of the Fetchner's renovation, so I'm not even quite clear necessarily on what it is they're designing. Despite our best efforts as neighbors, the Fetchners never shared any plans for a third edition in advance with us. The first indication we had of any plans of the Fetchners was from a public notice from the town that provided just the bare minimum as required on the application. We provided reasonable written change requests limiting exterior spaces facing west and on the roof level, but the Fetchners declined to respond. So the Fetchners had sent notice to our neighbors in the fall that while they have rented short-term previously, they had not rented in years and had no intention to rent in the future, despite advertising rental property starting in July of this past year for $12,000 a week and not registering it with the town of Middletown. Caring about the community. As year-round residents building someplace, I care about the community. I serve as a trustee on the Aquinic Land Trust, missing a board meeting right now, and I'm on the Conservation Committee of the Newport Garden Club, and I also chair the Ashurst Avenue Association. Our Neighborhood Street Association is comprised of 8 owners who collectively pay to privately maintain our charming gravel roadway. As a real estate agent for more than a decade, I know of no issues with long-term renters in our neighborhood. Short-term renters and owners of short-term rentals can lack accountability to their neighbors that threatens a neighborhood's character and security. Exterior balconies on the roof level at 576 Tuckerman, as well as east and west, we will have fewer locations for privacy. The pool house, pool area, and expanded deck have already expanded the Fetchner's entertaining spaces with short-term rentals often negatively impacting the enjoyment of our home. Note that we lived there for a year and then moved out and haven't lived there in several years. So now we want to expand. Now they want to expand. Do I have the same write-up you guys do? I think I've got the wrong one in my hand here. Do you mind if I just grab a different copy?
Yeah, go right ahead.
Oh, let's see, problems.
Expansion plans.
Yeah. Yeah. Now, this wasn't the copy I meant to send in. I had edited things. Anyway, now they want to expand further in our into our relocated entertaining and living space without actually a right to do so. We have done everything by right and accommodated so many other requests. I'd be heartbroken if after a long-awaited Forever Home's privacy, tranquility, and sunlight impacted by another home already granted expansion variances, though it is not their primary residence and have already used it for financial gain. It was disappointing that the town of Middletown, not the Fetchners, informed us as abutters of their new third-level plans. After all the conversations about house designs, it was surprising not to even send an email. We first saw the plans when we searched for the application on the town's website. When we reached out to the Fetchners to negotiate privately how to address issues with a third edition so we could support their variance as well as work to resolve any outstanding issues. Unfortunately, they did not respond to working with us to review our concerns. Next page is the listing, which does show a date stamp screenshot of September 22nd, 2021, when it was still available for rental. Though their home continued to be advertised for short-term rental as recently as this fall, the Fetchners sent an email to neighbors months ago stating they had not rented in recent years and did not plan to rent in the future. We moved out of the property several years ago for renovations, so we cannot confirm recent rental activity. When they have current plans, whether they have plans for short-term rentals, they have done so before and may decide to do so again at any time. For second homes, it's even more common than when they're used as a primary residence. Problems with the short-term rentals: hidden behind such large arborvitae, we didn't grasp just how close and loud the pool area would sound. Amplifying the noise was all the hardscape in the front yard surrounding the pool and the pool house. While the sounds of family fun is pleasurable to me, occasional noisy parties are to be expected. Renters hosting many families over several days grew unacceptable. We vividly remember renters who played loud country music starting early in the morning at the pool. Joe moved his office to the carriage house upper level loft to work, but with no air conditioning, the third floor office space was often stifling, even with multiple fans. When I took a dog out the first night, he started barking at a rather drunken man peeing next to my house. He dashed back to the Fetchner's property, and I did not pursue him. The next night, I saw a car pull into my driveway on Tuckerman Ave. When a couple got out of the car and locked it, I asked if I could help them, as this was my property. They stumbled off to the Fetchner's property, promptly flipping me off. I then walked back towards Ashurst Ave and noticed multiple cars parked along Matt Kirby's property on the lower Ashurst roadway. By the time I got back, the couple's car near Tuckerman had been removed. I went back to bed to the country music still blaring. I later awakened to voices yelling. Cars trying to turn around in our Ashurst driveway had collided. I stayed awake wondering if someone was injured on my property, and in these instances, would I have liability? We moved into the guest house in the far west end of the carriage house. Joe and I both did our best to ignore any noise. This time helped finalize our decision to move the house as far west as possible and build as high as possible to avoid the neighbors and maintain our water views. As a broker, I found most renters will be compliant when they are aware of violations, though some renters nearby were highly disruptive at times. I had not yet called the police. Roadway and parking concerns. There is no on-site parking available in our neighborhood. Where will more guests park when bedrooms increase? Shrouded by the trees on Tuckerman, our property seemed tempting for visitors seeking to park undetected. Once we departed, we could not monitor that any longer. My concerns regarding any accountability for damages that may occur by guests of both members and non-members of our street association, and the challenges with assessing blame and obtaining compensation for it. One example is recent damage to the stone pillar at our roadway entrance, hit by a delivery truck. If a member had not witnessed the event, I am uncertain whether a police report would have been filed and an insurance claim triggered that broke it into two pieces. On Ashurst Avenue, I have responsibility for maintaining Ashurst's private gravel roadway on behalf of the 8 residents using it. The Fetchers do not access our roadway, nor do they contribute to its maintenance. Some previous guests, or maybe party crashers not familiar with the area, seeking additional parking, they've parked in our driveway, along the roadway, and on some lawns, with and without permission, though it is illegal in Middletown. And there's a picture of 4 cars parked behind us at the Helen Jung's property, even though it's illegal for the Fetchner's guests. The perfect neighborhood. With such a large family that's local, we knew lots of on-site parking was vital. As consultants, we both work from home and constantly must video conference, so peaceful location was important. Charlie is autistic, and we looked for a quiet residential neighborhood close to where Charlie can enjoy nature with no need of a car. I think I'm repeating that one. So variance granted in 2016 for the deck expansion. During the purchase, this might be, we learned that during our purchase under contract, we learned the Fetchners requested the deck expansion along our border that required a zoning variance. Tim Germain, 592 Tuckerman's previous owner, contested it, concerned it was too big on such a small lot and too close. We decided not to contest the deck expansion, hoping to establish goodwill with the Fetchners. We experienced why Mr. Germain warned about the existing noise levels around the pool area. We soon regretted the deck's location, as it is the primary dining space, and it is closer and in far more use, and used far more often than the pool area and surrounding hardscape patio. Oh, and surrounded by hardscape patio. After living there a year, the hardscape pool made working in the main house very challenging. Their large trees were still a concern for our main house's location due to light and safety concerns in storms, but the noise was intolerable at times. Our son Charlie could not sleep in the bedroom in the main house, staying instead at the far west bedroom at the dead-end street. Even when we moved into the carriage house apartment, we still found the hardscape magnified the noise, working with all the windows closed in the heat because of no AC. We redesigned the house over and over. We shared many iterations with all of our abutting neighbors, full sets of house plans, and encouraged their input and feedback, as we always cannot know how our design impacts their experience, and we deeply care about that. I show some pictures of our space on the second level. What we ended up doing, well, I'll keep reading. The southern deck allows us some limited privacy, but it is sufficient to enjoy sun and the hot tub. The third-story addition so close to us will impact our privacy and year-round sunlight. To ensure sunlight in the main living space in our house, we cut the deck short, and instead we have a retractable awning to make sure that we can have natural light year-round. And there's photos depicting where you can see how close the neighbor's property is to the deck space. The following page gives an example of the very tall trees when we bought the property that shadowed the house that we had. Concerns with short-term rentals. Owners are not permanent. Well, the building variances are. The next owners may not be a nice family, nor limit expansion efforts. Highest and best use means top bids, but not top neighborhoods. Not their primary residence. A large vacation home with a pool house and decks on both sides could change the character of our quiet family neighborhood with a party house atmosphere. Abutting a quiet dead-end street in an older residential neighborhood, this property already pushes boundaries on three sides. When the noise levels rise in the outdoor dining spaces, 592 Tuckerman is the primary recipient of it, while others like the Hellendrungs are quite some distance from their pool with two houses in between them. Similar variance to this one was approved 20 years ago, and then it was overturned. 20 years ago, the prior owners of 576 requested an additional level, and though approved by the zoning board, it was later overturned on appeal by a neighbor not represented at the zoning board when the zoning board approved the variance. A shadow study informed us. Living in our house for a year, we noted how much shadows and sunlight shifted during the year, and natural light is a priority to us. We ordered a shadow and sunlight study by our architect during our design process from our architect to better inform us about shadow intrusions to maximize light. Has one been done by the Fetchners? I'm not aware. Concerned about the structure on light and privacy. We're very concerned over the seasonal impact on our light and privacy based on the design. We are already heavily shadowed at times, so we are very concerned a much taller structure may impact our main light source. All of our sliders are installed on the south side to capture natural light year-round. with a retractable awning on the porch for ample light. So multiple pictures to show views. I apologize to folks who can't see them. So hopefully the board has a sense of the proximity and the impact.
Thank you for your testimony.
Thank you.
Mr. Jackson?
If I could call Mr. James Hool, please.
Mr. Hool? Please raise your right hand. Do you swear the testimony this evening will be the whole truth, nothing but the truth?
I do.
State your name and address for the record.
James Houle, Houle, 198 Union Street. Do you mind if I pull the mask?
You can take it off.
198 Union Street, Portsmouth, Rhode Island.
Excuse me, Mr. Chair. Pardon me, excuse me, I'm over here. The attorney for the applicant has questions for the previous witness, I believe.
Oh. Mr. Hool, if you can stand by.
Sure.
Thank you, Ms. Desato.
Sorry about that.
I don't think that's working.
Here, you can, we can go back and forth if you need to.
Better?
Better.
Thank you. Thank you, Ms. Tabor. Ms. Tabor, you testified about a few different times when you read from your testimony, your letter to the board, about the noise nuisance and has been a continuing issue since 2014, and you testified that you purchased a property in 2016, is that correct? And this noise nuisance, would you say it's been ongoing since you purchased the property, or was it more recently?
We moved out of the property, I believe, 2008, 17 or 18. So we were not there in recent years to know whether or not. I can't attest to it, whether it's been rented or not. We've observed different people there. It can be friends, can be anybody. I wouldn't know and have not lived on site to monitor what's been going on since we moved out.
So I apologize, just to, so I can clarify my question. So when you moved to the property in 2016, so back up.
Yeah.
You testified about a noise nuisance.
Yeah.
And you also testified that you purchased property in 2016. And then my question was, has the noise nuisance, and I didn't say who the noise nuisance was, I was just asking about the noise nuisance, has it been continuous since 2016, a continuous process, like 2016, 17, 18, through today?
I can't tell you because I don't live there.
Okay. You don't live there currently?
Do not live there currently. We moved to Newport.
Okay. And so when did you move to Newport?
Well, we first moved to, we were in the carriage house. Joe had a hard time working, so we had to move to, we got a condo in New Jersey close to his job so he could work and that we could be there because we didn't have a full kitchen in the carriage house. And we had him tear down the main house and just abandon it. So we didn't have a kitchen. We really couldn't live there full time.
Okay.
So we were there kind of on and off living in New Jersey.
Okay.
And kind of back and forth.
And so that was starting in approximately what year?
2017?
So you were there from about 2016 to 2017, and sometime in 2017 is where when you relocated.
Or 18, yeah.
Or
Yep.
some,
I can pull a timeline if I need to, but yeah.
you don't, it's not necessary.
Yeah.
So sometime, let's say, late 2017, early 2018, you relocated to New Jersey, and you stayed in New Jersey?
We used the carriage house as a second home.
Okay.
And we were back and forth to try to monitor everything. We needed to be on top of what was happening on the property.
And how often did you use the carriage house as a second home, and what was that time? So you were in New Jersey starting, let's say, end of 2017, beginning of 2018, and let's first let's say, for how long were you in New Jersey?
Probably 2 years.
And that was, is it fair to say that was your primary residence for 2 years, but you were coming back to 592 Tuckerman as well?
I would say it wasn't our primary residence, but we ended up spending more time there because it was just convenient to get work done.
Right, so because your testimony was that Joe worked in New Jersey? And
Yeah, the company he was working for was in New
Understood.
Jersey.
Thank you. And so, but you would come up, you know, and that was for 2 years, so
Yeah.
I'm a numbers person, so
Yeah,
you have to
let's go,
forgive me.
let's go.
So from end of 2017, so let's say through to the end of 2019, beginning of 2020, you were primarily in New Jersey, but you were frequently coming up on the weekends to stay in the carriage house. Is that a fair?
For the last 2 years, we've been living at my parents' home in Newport full-time and monitoring daily, or as much as possible, the construction at the end of the day.
Right, because that you tore down everything that was existing at 592 and built
We
this.
attached to as far west as we could and just attached to the carriage house.
Right, so if I am understanding your testimony correctly, so really the only time you were full-time at 592 was from 2016. And when in 2016 did you purchase the home? Is it the beginning of 2016, the end of 2016?
God, I'm so bad. Do you recall? Oh, okay, so he's got the dates.
So, and then, well, move out, but your testimony was at some point you were in New Jersey for approximately 2 years because of Joe's daughter.
Back and forth, yeah.
Right.
Yeah.
And so only full-time in the carriage house or in at 592 for a year, and then kind of back and forth until the last 2 years, which let's just say 2020 through current day today, you've been in Newport living, but monitoring the construction going on in the home. Okay. So the only time that you were fully at the property living was that first year and a half. And that's when you are saying there was the noise nuisance that you had the issue with there. And was that noise nuisance the Fetchners or?
I have no idea, I couldn't see.
Right. So you don't even know who the noise was coming from?
Nope.
And you don't know who the cars parked, wherever they were parked, you don't know if they're associated with the Fetchners, is that fair to say?
Yeah, I did, well, yeah. So from upstairs, if I wanted to look and try very hard to see, yeah, you saw the whole backyard was filled with people, the whole front yard was filled with people, the decks were filled with people. People were everywhere. It was, I think at one point I ended up meeting, because they needed directions, at least 3 mothers who were going out to go get stuff and wanted directions to the closest supermarket. That was 3 of the moms.
Right.
And there were more. It was a big rental.
Right,
It was
but-
just a big rental. And not surprising. You've got a pool. They were having a blast, but it was
And
day and night,
they
night
were
and day.
enjoying, well, if they're in the pool, it's definitely, you're in New
But
England,
at
it
2
was the summer.
a.m., you don't need it. I don't need it at 2 o'clock in the morning. Yeah.
Understood. I just want to make sure that we're
Right.
staying from one thing. I want to keep one thing at a time. So this noise nuisance, right, that you're complaining about, you testified about. During that time, did you call the police?
No.
Did
Good
you?
we wanted to establish great relations. We were the new kids on the block, and we were trying very hard to get to know our neighbors. We never got invited over once. We invited them at least a dozen times to go out, go to dinner, come talk. We made efforts, very much so.
Right. So, but with the noise nuisance, right, you didn't call the police. You didn't report what you thought was some type of a short-term rental situation. Did you report that?
I called
the-
Elena.
to who?
The next morning, on July 5th, I recall, in fact, we have an email from my husband. I'd like to enter into evidence, actually, where it's 2017, and I have a copy of it. He specifically says, here's Elena's contact information, and it's not your responsibility to manage the noise of the renters, and if we need to get attorneys involved, we will. And I can produce that into
I
evidence.
have to apologize. I didn't hear who you contacted or who that was?
I was trying to contact Elena.
Oh, Elena, I'm
Yes,
sorry. I didn't
yes,
hear Elena.
Mrs. Fetchner.
Yes, yep.
Because when I have issues with a neighbor, I call the neighbors, I don't call the police.
Okay.
And I didn't have her contact info, I didn't know it was being rented, I didn't expect any of it, so turns out I asked my husband, and he had her contact phone number, and he forwarded me an email that I can introduce. It's dated in 2017, but it very clearly states, here's Elena's phone number. It shouldn't be your job to manage the renters in her property. It's their job to manage those people, and if we need to get attorneys involved, we will, is what the email said. It was that bad in 2017.
So in 2017, the only person that you reached out to about the noise complaint was Elena, the
I
neighbor.
contacted the Fetchners to
Right.
tell them I figured they have no idea what's going on.
But you testified this is an ongoing noise, but you never, I just want to make sure that we're clear, because that you didn't reach out to the police and you didn't contact the building official, you didn't report any kind of violation, that they didn't have a
I wanted
permit.
very much to work with the Fetchners because I did not know if they were aware.
And did you look to see whether they had pulled a permit for short-term rental? Did you do that type of investigation?
No.
So you don't know if they did or they didn't?
Oh, I wasn't trying to investigate my neighbors. I just wanted them to be aware that the renters were going crazy.
My
Attorney
apologies.
Default, can we kind of move this along?
I was confused, and I just needed to make sure that we were...
It was bad enough we knocked the house down.
Understood. So the others, you had testified about privacy, the noise and everything like that. Now, the noise and the privacy, there's arborvitae that separate your property, correct?
Interesting, yes. And
And you removed, I'm going to say 6, but I don't know if that's exactly the amount. But that arborvitae that was blocking, they were tall ones, right?
Sure, I can tell you all about how it happened.
No,
The town of Middletown came and said, you need a retaining wall here in front of the arborvitae. Our contractors came and said, we'll kill the root balls, these are dead. If we put this retaining wall in, those will all be dead.
But
I
Ms. Tabor?
contacted and replaced, in 24 hours, I found 20, in the middle of COVID, 20 of the tallest arborvitaes and had them planted 24 hours and sent Elena an email to say, I don't ever want you inconvenienced, but these trees would have been destroyed. And if you looked at the tall ones, I have photos, you see green, but it's all brown, dead trees because they're so overgrown, they only get it and they don't regenerate.
Understood.
So, yeah.
But you
We didn't want to
removed-
lose them.
There was arborvitaes that were blocking the boundary between the two properties
Well,
and
there's a
providing
fence.
privacy.
There's also a fence.
And you're
Yeah,
removed.
and
some
we've
of
replaced
those.
them. They're there.
Well, remove the taller ones, correct?
Yeah.
Yeah, thank you. Thank you, yeah. I'm so sorry, yeah.
Yeah, I apologize. Is this
Sure.
better over here? Yeah. No, no worries. So then, just a couple more questions, Chair, if you'll indulge me. So just fast forward to you had mentioned that you reached out to the Fetchners privately to see if you could work things out. And are you referring to the email that Mr. Jackson sent to
I haven't
them?
seen it, so I don't know, but we had several issues we had discovered when we did surveys that the agreed-upon property line by both of the former owners, they had it wrong.
So if I can, let me just, let me ask the question. So when you're talking about privacy, right, this is the things that you were talking about, privacy, and that was foremost, and that there was the noise nuisance. Okay. So in the list of demands, does a permanent view easement, that these were the 5 demands that if they agreed to them, that you would remove your objection?
That was my throwaway. They had planted a new tree that literally was going to take my whole water view from my second floor on the very front corner, right in front of us, that didn't provide them any advantage.
So this was just
It was just to
this was
say, if you can do all those
This
things.
was a joke.
No,
to
it was our ideal. And if they thought that was fine and thought, oh, no, we can replace that, we offered to replace their trees, we offered to pay for their re-landscaping, and they re-landscaped every single thing in their yard except the big trees until they did it later for their own purposes.
So the permanent view easement, nothing to do with noise nuisance. The tree located in the northeast corner of the property wouldn't
Oh,
rectify
no,
a
it's fine if
noise
it stays.
nuisance.
It was just, like, if
Right.
we're gonna do everything, let's just think of everything we'd love to do to live happily ever after.
Asking for a portion of the property wouldn't eliminate the noise nuisance, would it?
We didn't ask for a portion of the property, and I believe they might be over hours in the back. It turns out the property line was straight, but it's jogged. So where we get stuff, they lose stuff. So I just think it's we'll straighten it out. I sent them a thing saying, happy to work it out with you.
So, and in any of your communications with the Fetchners, was there anything communicated to them that the reasons for the view easement, for any of this, the reconstruction of your property or the objection of what you wanted to do was to have any kind of fit for the noise that, or did you ever say like, hey, our son has issues and suffers from autism and we really would like.
We tried. We could not meet with them.
No,
We tried.
My question was in any of the emails, because you sent Elena a few emails
Yes.
about these.
Yeah.
Did you ever mention your son and his issues with autism, that was one of the main reasons why you needed this relief or this help?
I lived with the decision we made to give them that setback. And I had to live with now building a vertical house that had a second kitchen area, a second dining room on the third level because it might rain, and a roof deck. So I could have my daughter's July 3rd party not be right on top of all the noise of their neighbors. We went up and west because they were low and east. And I have nowhere else to go.
Understood. I'm going to take that as a no. No further questions.
Thank you.
Thank you, Ms. Tabor. Mr. Jackson?
Thank you, Mr. Chairman.
Mr. Hull, I believe we swore you in. Can you state your name and address for the record?
Sure, it's James Houle, Houle, 198 Union Street, Portsmouth.
Mr. Hull, you've appeared before this board on numerous occasions, so we're going to accept you as an expert witness in the area of real estate appraisal.
Thank you.
Thanks. Mr. Houle, if you could just describe to the board the steps you undertook when you were engaged to give an analysis of this project and what your conclusions are. Thank you.
Okay. Essentially, what I did was to look at the petition, look at the plans, visit the site, of course, the neighborhood, and form my opinions based on the request, which was for a dimensional variance. So I looked at the criteria that are in 903, specifically in granting the variance. I won't really bother, maybe I should take a minute to go back. The Fetners are looking to use the part of the building that's already within the setback and go up another floor, adding 2 decks, one on the roof, one off the 3rd floor. So they're required, because they are extending the nonconformity, to have a dimensional variance. So I looked at the criteria specifically for dimensional variances. One, that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure and not due to the general characteristics of the surrounding area. I didn't really spend a lot of time with that when I was preparing the report, but when I was hearing the testimony tonight, there was, the opinion was stated that the hardship was the shape of the lot. In point of fact, this is a 20,000 square foot lot. It's conforming lot size. It does taper, but essentially in the middle where the house would be placed, or any other addition, you have about 100 feet. So of width, which even within since the main part of the house is already shifted off to the side, within the setback, it leaves a significant amount of space on the rest of the lot to the south side, which is not being utilized. So I'm not quite sure how the characteristics of the lot actually impacted this in any negative way.
Can I ask you a question?
Yes.
So regardless, if you went to the south, this has been, been applied several times.
Stop.
If you went-
Say it again. I didn't
Okay,
quite-
so if you put an addition on to the south, you add additional, another 1,000 square feet that isn't above, but it's to the south. We're still here having the same conversation, correct? Because the deck is in place and the side yard variance, we're still here having the same exact conversation, whether they go up above or they go to the south. Is that correct?
I'm not sure if they go to the south.
Right. But the reason we're here is because the deck is non-conforming and the garage is non-conforming.
I agree.
Otherwise, we're not here.
No, I agree.
Okay, so to imply that you can go to the south or you can come closer to Tuckerman Avenue is completely incorrect. Is that right?
Yes, I think you are right about that. I think that once you add on to the building, we're going to be back here anyway.
Yes.
Okay. I think it was
They
just
can't
that-
add any other square feet short of tearing the deck off, which has already been approved by the zoning board. Is
Right,
that correct?
right. You'd have to remove the deck to do it. You're absolutely right.
So, Mr. Houle, just to follow up on that line of reasoning then, the deck was installed by the Fetners, correct?
Yes, it was.
So would you then conclude that they essentially have created their own hardship?
Oh, there's no question about that.
But the garage was not. And so if the garage is still there, we're still in the same spot. Is that correct?
I'm really not
The
following that
addition that's
logic.
being proposed by the Fetners is along the north boundary line adjacent to my clients. It's not in the vicinity of the garage.
But the garage is non-conforming because it's right up against the south lot line.
Okay?
And we're here getting.
We're here
asking
because
for-
they want to build within the north setback.
What's that?
We're here because they want to build within the north setback.
That's because it's currently non-conforming. The whole structure is currently non-conforming, both on the south and on the north.
I think the argument we're making is there's opportunities for other building plans which meet the setback requirements. And part of what's obstructing that opportunity is the existence of a large front deck.
How could you do that without tearing the deck down?
That goes to who created that hardship. They created that hardship for themselves. So if they want to remove the deck and expand their living space, they have the opportunity to do that.
Want them to tear the deck down is what you're asking.
I'm not asking them to do
We've
anything.
been talking about this for now, over 2 hours, and we've been going round and round and round with implication from each side, but no one's really saying what your issues are, so if we could get to that, I think we would all appreciate it.
Well, I think that actually it's kind of interesting you say that because we really haven't had an architect or an engineer come up and actually explain what the plan was. And I think that would have really helped quite a bit because a lot of my testimony is based on my interpretation of the plan that was submitted. I tend to agree with what you're saying, which I think is probably part of the reason why I didn't spend a lot of time with it at the time, because there were unique characteristics of the house in the sense that it was already placed there. But the concept that the lot itself would create the problem is really incorrect, okay? Number two, which is that the hardship is not the result of prior action, we've just discussed that. The deck actually, the current owners were granted permission to build the deck. So they really have created their own hardship. They knew the situation would exist, and now they're building over what was the encroachment. So I believe that they really have created their own hardship. The third is that the granting of the required variances will not alter the general character of the surrounding area. The comprehensive land use plan strives to protect property owners. With decks overlooking the pool area, one of the problems that you have is that's a natural inclination of people who are staying in the house to actually communicate, especially because it's the pool area and the decks are overlooking and they can speak to one another. There's a natural tendency to create greater noise when people are actually utilizing all those spaces. So I think that it can indeed create a problem in the neighborhood. The deck on the rooftop, I really do consider kind of a danger, quite frankly, to have that there because I really think that it is really an extension Now you're going beyond just living space, and you're adding a factor that I consider to be really non-conforming, and pushing the envelope of the height of the building. The relief to be granted is the least relief necessary. This is really where I have more of a problem. If we had had somebody talking about the design, I was very interested because I did look at the designs of the Fetners. And if you look at the proposed third floor space, I noticed that both rooms have access to bedrooms and each of them have closets. So it appears more that they're intended, the design of this is almost intended to be 2 bedrooms on the third floor. Mr. Fetner also talked about how the staircase was going to be moved on the second floor, which would generate the elimination of one of the bedrooms. And actually, if you overlay the second floor and third floor plans, it appears as though the staircase wells are right on top of one another. So I'm not sure that there's any real indication that there's an elimination of any of the bedrooms. When I looked at these plans, it clearly looked as though you were adding 2 more bedrooms, as well as the deck overlooking the pool and as well as the roof deck. So it really did appear to be a significant expansion of the utilization of the property. I don't think at all that this is the minimum relief. I think it goes well beyond the minimum relief. And last, the hardship to be suffered by the owner of the subject property is more than a mere inconvenience. I'm not really quite sure that I see that in this particular case. I understand everybody would like to take advantage of the height of their buildings to generate views, but I think in this particular case, the fact that they have to go 3 stories encroaching into the setback is a little much. So my opinion is that really when you look at all the criteria for variances, I don't believe the plan really meets those criteria.
Any questions for Mr. Hool? Attorney Default?
If I could, just, I didn't want to interrupt Mr. Curtin's question and the chair's clarification. And I'll first, I don't know whether to make a point of clarification or to pose it to Mr. Hool. I think there's some confusion. We asked, Mr. Curtin asked us to get to the heart of the matter. And Mr. Hool testified that that the Fetchners did in fact create the hardship by adding the deck. Is that, am I mischaracterizing, or is that what you testified?
No, you're right, because they did say that. They had to come in and ask for the relief. So at the point where they're coming back and asking for more relief, they had testified earlier that they were unaware of the encroachment of the property when they bought it. Mr. Jackson, in some of his subsequent questioning, brought out the point from Mr. Fetner that by asking for this relief, they had well acquainted when they had extended their nonconformities on the property, and they became very aware that they were generating a nonconformity that was greater than had been there before.
Okay, but to be clear, Mr. Hool, the Fetchner's petition, and to be clear to the board, the Fetchner's petition is not asking to build over the deck. They're not asking to build over that part of it. So even if, as Mr. Curtin pointed out, even if we removed the deck and wanted to build additional living space, we're still back here because the existing structure is non-conforming, not the deck. We're not asking to build above the deck. We didn't create, the Fetchners didn't create the hardship from which they're seeking relief, the deck. They're seeking relief from a hardship that was existing before they purchased it. Is that correct?
Yes, but it's also not correct. And the reason why I say that is because, all right, so in terms specifically of the creation of the hardship, the fact that they have encroached in the area that they are trying to use is really, they became aware of the nonconformities of their lot, so that by asking to use that same encroachment area, they're actually going over the area that they had created the hardship. They had created a hardship in this particular situation because they already knew that they were encroaching further, making it more nonconforming. I think that one
Mr.
of the...
Hill, I have to, you said yes when I asked you. They didn't create the hardship that they need relief from, which is the 14.4-foot encroachment into the 20-foot setback, which we need. And Mr. Curtin asked you, even if the board made them, if the deck got taken down, we would still, the petitioners would still be back here needing the same relief to add anything on to their structure.
No, they would not be asking the same relief. They would be asking dimensional relief, but it could very well conform much more easily to the question of least relief necessary. That would have been the least relief necessary. What they're doing now is going into an area that they've already expanded their nonconformity. So it becomes not the least relief necessary. Would they be back here? Possibly. Would they be back here asking for the same relief? No.
But the relief they would need, if the deck was down, is 5 feet 6 inches, because the existing dwelling is 14.4 feet away from the right side setback. That's what is being requested tonight in that petition, and that's exactly what we would have to apply for. Now, that's the relief that is requested. When we discuss the standard least relief necessary, you're conflating two issues. Now, the standard about least relief necessary, I understand, that's something separate. Do you stipulate we would be right back here asking for the same exact relief? If the deck was torn down, we would be asking for a dimensional variance.
You would be asking for a dimensional variance.
For
You would not be
amount.
asking for the same exact.
Same amount, the same amount, 5
You have no,
6
we
inches.
don't have the petition, we have no idea what it is.
We're not asking relief for the deck. So,
You can
Chair,
carry on.
Yeah, and as far as the number of bedrooms, you said you put the plans over each.
I did.
And in your calculation, just because I want it to be clear, did you count 4 bedrooms?
On the second floor.
And there's currently 4 bedrooms existing now, and there will only be 4 after the renovation.
The plan does not show that. What I testified to was the fact that I had looked at the plan.
Okay.
The plan shows 6 bedrooms.
So if I tell you currently there's 4, and you testified that there's 4 that are going to be there, but you testified there's 4 per the plans submitted to the board. Is that correct?
You better repeat that question.
Sure, I will. I'll start again. You testified that 4 bedrooms are proposed per the plans that were submitted to the board.
4 bedrooms on the second floor.
How many, were there bedrooms on the first floor?
No, there are 4 bedrooms on the second floor.
Right.
And the plan shows what are apparently 2 bedrooms on the third floor for a total of 6.
And those are rooms with a closet that are supposed
Have bathrooms, have closets.
Okay.
All right, in an area like this, it's very typical to maximize bedrooms. And again, you know, the Fetners have said they're not going to be doing short-term rentals, but they clearly are making the building more attractive to the next buyer, who would be likely with a swimming pool and several decks, making maximum use of those bedrooms. They would be increasing the attractiveness of the property. We know that a lot of houses in this area are purchased by people who want to maximize short-term rentals. It would fit those criteria very well. And so the plans that I was using that were submitted with a petition show 6 bedrooms. they show 2 roof decks. I mean, they show a roof deck plus the new third-floor deck. And it clearly is an expansion of the utilization of the property by a great, the utility of the property has increased beyond just the addition of the extra square footage.
And you, thank you, Mr. Rule. And last question. So you've appeared in front of the Middletown, the zoning board previously, I know.
I have on occasion,
Yes.
yes.
And you have testified for dimensional variance and relief from side yard setbacks, I would imagine, is that
I have.
correct? And when it's been something like this, have you testified for like, is a non-conforming use, a non-conforming structure, and you needed a setback and previously?
Yes, but I will also say, as I just said
That-
earlier, every petition is different.
Understood.
Okay.
Thank you. Thank you, Mr. Well, Mr. Jackson?
We have no other witnesses.
Mrs. Default, Ms. Default, you don't have any more witnesses?
I don't. I just wanted to clarify something.
What I'd like to propose is that you both issue a statement, and then we wrap it up.
Absolutely.
Okay, hold on.
Oh.
Mr. Curtin?
If we were to entertain your proposal, but it were a condition of the board that the rooftop deck be removed, would that be something you'd be open to?
That's exactly what I was standing up here. I was going to say to the chair. The Fetchners would agree to remove the rooftop deck. And yes, that's exactly why I was standing up
Do
to
you have
say.
any other closing statements?
I would just say to the board, I know that you've heard a lot of testimony, and I agree that I believe we would be right back here. I want it to be very clear. It is a dimensional variance because the single-family dwelling is located in the side setback. Even without the deck, we would be back in front of the board requesting relief, short of demolishing the whole entire structure, which I don't think the board wants to make these petitioners do. They have this non-conforming structure. They're trying to just put a little more living space into it and are willing to give up the widow's walk up on the rooftop deck. And I believe that you've heard significant testimony about how we believe this passes the standard of a dimensional variance per the Middletown zoning ordinances. Thank you.
Thank you.
Question for you.
Mr. Silva?
I have one question for you. Do you have a problem with us putting a condition that it's going to only be 4 bedrooms?
So that yeah, it's 5.
No, they were going to eliminate one downstairs, and they were going to put one upstairs. They had 4, they were going to eliminate one downstairs, and they were going to put one upstairs, and that was going to keep 4 bedrooms.
That was the testimony.
That was the testimony.
And that's
I've been on this board for years, so, that's what you guys testified. And if not, we can have it read back from the stenographer.
Understood, Mr. Silver. That was my other point that I apologize when I was coming up. I was trying to clarify with the client and with the board exactly what they were requesting and what Mr. Hoole's testimony was and how he read the plans. If I may ask them, the condition of, the board would want to condition the approval on only keeping it at 4 bedrooms and not allowing them to add, I think Mr. Hoole testified that it was 6 bedrooms. So if it would be a condition of keeping it at 5 bedrooms,
No, it'd be
then
4 bedrooms. They said they were eliminating one they're going to eliminate one for the stairway, they said. That's what was the testimony.
Right.
How many are originally?
And then they were going to add one on the 3rd floor. That's what they said.
And I believe that there was originally
So then that would be 4.
There was originally 4. If they were eliminating 1
And adding 1.
I thought they were adding 2.
3 and 1 is 4.
I thought they had 4. They were eliminating 1 and adding 2 more.
So they were adding a bedroom and a family room, was the
On the-
exact testimony. That was the testimony
That's
from,
from the testimony.
So, Mr. Fetchner, if you can, yep.
Sorry, Mr. Chairman. I know we talked a lot over a long time, but yes, we needed to, the plans are such that we needed to eliminate one bedroom in order to actually get around to the third floor. And on the third floor, we now have a new bedroom, which is number 4, as well as a family room and a bathroom.
Okay, that's the testimony we heard.
That's 4 bedrooms
4 bedrooms.
total. That's it.
4 bedrooms.
4 bedrooms total.
That's what he's tested. So that's what we heard, so that's good.
Okay. So the answer to your question is yes, Mr. Silvera.
Thank you.
My apologies. Thank you.
Mr. Jackson, would you like to wrap it up?
Thank you, Mr. Chairman. It's the applicant's burden to establish that they've met all the elements of a dimensional variance. I don't think they've even come close. What we're talking about is building into a setback. We acknowledge that the existing footprint is already there. However, through the testimony, what we were trying to illustrate is that the applicant, if they spent some time on design, could have come up with a different plan that didn't require the relief that they're seeking this evening. They could have complied with setbacks. They chose not to. It was easier just to go straight up. So now they're asking to build 3 full stories into a setback. And honestly, at this point, with the conditions that they agreed to and then requested not to agree to and then have agreed to again, I'm still at a loss as to how the net result of 4 bedrooms is any different than the 4 bedrooms they have now for a second home. So I'm having a hard time seeing where the hardship is, where the least relief is, and I just simply don't believe they've met their burden. What they're proposing will have an impact not only on my clients but other abutters, and I don't think it's, I would respectfully request that the board deny the application. Thank you.
Thank you, Mr. Jackson. Is there anyone either in the audience here or on the Zoom call that would like to speak either for or against the petition? What we call a Zoom pause. A hand came up. The chair recognizes, I can't even come close to reading it. Payson.
We do have
We have a letter from this gentleman.
correspondence from Bison.
Angela, can you let Mr. Pison in? I'm just going to ask him to keep his Mr. Pison, if you can keep if you can keep your comments brief because you've got 2 letters in the file, that would be great. Raise your right hand. Raise your right hand, please.
I'm on.
Yes,
Yeah,
you're on.
I'm having major audio problems.
Okay. Do you swear
I've
the
got you
testimony-
both on the phone and also through my computer.
We have
anyway,
both we have
let me
both
just-
letters in the we have both letters in the file from you. But if you could raise your right hand and swear the
wait a second.
testimony, do you swear the testimony this evening will be the whole truth and nothing but the truth?
I couldn't hear any of that.
He's got to turn off one of his devices.
You have to turn off one of your devices, sir.
You're getting feedback from yourself.
I have to turn off one of my devices.
Your phone, turn your phone.
Well, let's see, how am I going to do that? Because right now I don't have computer audio.
Well, it's just state your
Somebody say
name.
something for me.
Just to tell, what do we do in a case like this? He's got two letters in the file already.
I would ask the applicant.
Okay, I've got
to-
it back. I've got it back and I'm gonna turn off my phone right now. Okay, because really I'm just transmitting, I think.
Okay, can you hear me?
Yes, I could hear you.
Okay, do you swear the
I'm trying to get
testimony
my
this
phone
evening?
turned off. What's that? Wait a minute. Okay, that's gone. You can hear me, I can hear you, I hope. Boy, I don't hear a word right now.
Oh, I'm not saying
Now I
anything.
do. Okay, good, good,
Can you
okay.
stop for one moment, please?
Yes, I will, please.
Can you raise your right hand?
Yes, I can.
Do you swear the testimony this evening will be the whole truth and nothing but the truth?
Yes, I do.
Mr. Payson, you have 2 letters in the file already, so I ask that you respect our time tonight and keep your comments brief.
I really worked at that. Basically, I didn't realize I could attend. until about, late last week. I didn't know it was on Zoom. So let me just read what I was going to say, and I did this so I could minimize your time. Okay.
Okay.
Okay. So can I start?
Yeah, absolutely.
Okay. Please accept the following comments as an addition to my July 23rd letter supporting your approval of the subject variance request. That's this variance request. I attended board meetings last summer and fall to speak on the subject because of the significant impact your decision has on the numerous small substandard to R20 property owners. My understanding after the 68 meeting was that as long as I did not exceed the as-built footprint, I could put a second floor on my ranch foundation. The specific R20 parameters were to control new build. You have the responsibility to determine if my construction plan has a positive, neutral, or negative impact on the neighborhood, and to reject the applications if there is any negative impact. The abutters and new homes on Ashurst have set a new size bulk standard for the neighborhood. Let me just stop for a second. My July letter to you basically described my 55 year. I bought my house in 66, and it described what our neighborhood was. The neighborhood that was described with that doesn't exist anymore. The neighborhood that we now have is the neighborhood we're talking about right now. Okay, anyway, the applicant's property does not come close to the standards that have been set. Vision appraisal data, this gross area as 4,644 square feet for the applicant structure versus 9,367 and 8,944 square feet for the abutters. Living area is 2,300 square feet versus 4,531 and 5,554 square feet. Now then, do you buy the reason I emailed this thing and turned it into a letter was to get you 4 pictures. Do you have those 4 pictures by any chance?
We do, Mr. Fugit,
Then
and if you can keep.
I can reference them as picture 1, 2, 3, and 4.
Exactly, but we've already had that in our file, and we've already reviewed that. So if you can add anything new, I'd like to wrap the hearing up. So we understand, we understand your comments.
Okay, well, I said walking Ashurst towards the beach, you see an abutters ranch, picture 1, where a second story was added. Next, the applicant's 2-story house, picture 2, with and basically, I'd like you to make sure you look at that and see what it would look like with the 3rd floor. The side yard setback space is the 3rd picture. The other abutters new 3-story house still under construction is picture 4. And in picture 4, you can see the huge difference in bulk between the applicant's house and these abutters' houses. Let's see. Another thing I'd like to address is that the neighbor's privacy concerns are a two-way street. I'm sure the applicant has the same concerns for his family privacy. The short-term rental concerns are similar. None of us want to deal with rowdy short-term rental situations. A recent Middletown newsletter covered the problem very well. The town council is collecting data, and it looks like the incident rate is lower than expected. Short-term rentals are not a problem that the zoning board should be trying to solve.
Mr. Fugett,
Yes.
I'm just gonna, you're for the project. We acknowledge that in your two letters. And we're not here to discuss short-term rentals, and we really can't discuss all the issues. We have your correspondence, and it's a part of the public record. So at this point, we've been speaking for 2 hours and 45 minutes on this. So I'm gonna log you as for the case, and then I'm gonna, unless there's somebody else, I'm gonna close the public hearing.
That sounds great. And I thank you so much for doing what you do. I really respect that.
Thank you. Have a good evening, sir.
Thank you. Bye.
Angela, I don't see any more hands raised. So seeing none, I'm going to close the public hearing.
A quick question. There was one letter that came in today. I wanted to make sure it was part of the record. The last name was Bohan. It was very, very short.
Yes, it is. It's one of the... Just so everyone in the audience knows, all the letters that come in are considered part of the public record, whether we read them or not out loud. And so if there's any appeal or anything that goes on after the case, they'll all be part of the public record. So seeing that there's no other comment, I'm going to close the public hearing and entertain a motion. Mr. Silvera, I think you had some things, some conditions you wanted to put in, so.
Motion?
Anyone, I'm not allowed to.
I know. Okay. I'll make the motion to grant the petition with a condition that it remains at 4 bedrooms, as stated in the testimony. 3 bedrooms on the 2nd floor, 1 bedroom on the 3rd floor, and a family room and a bathroom on the 3rd floor. And the second one is the I'm sorry. The second one, I apologize. The second one is to eliminate the rooftop widow's watch. Is that what it is?
Mm-hmm.
Okay. Eliminate the rooftops widow's watch. There's going to be 1 bathroom on the 3rd floor, yes. There's 2 on the plan?
I don't think that matters. These are the bedrooms that we were concerned with.
Well, the room that they're calling the family room has a closet and access to a bathroom, so that could be considered a bedroom.
You got to talk into, I'm sorry, Judith. Yeah.
Oh, sorry. Yes. On the 3rd floor, the family room has a closet and access to a bathroom. And then what they're calling the bedroom has a full bath and a walk-in closet. So my point is that the family room could be considered a bedroom.
You know, I just had the discussion with my wife. It has been half a year. In the last reiteration of the plan, we actually divided what was supposed to be kind of a tandem bathroom into 2 bathrooms to get access from so that in the family room they don't have to walk into the bedroom to use a bathroom. So that's correct. It's actually is it 2 full bathrooms? No. It is 2.
It is too full. There's a...
Ms. Desatel, the fact that they testified that it's only going to be 1 bedroom on the 4th floor, is that sufficient for our motion?
I would, again, because there's a motion pending or about to be made, I would ask the applicant to, again, verify exactly what the specifications are for the 3rd floor.
So, Mr. Fetchner, if you can just reiterate for the record that your intention is a total of 4 bedrooms, 3 on the second floor and 1 on the third floor.
Correct.
If you can just testify that one more time on the record?
So in terms of bedrooms, there's going to be 3 bedrooms on the second floor, and 1 additional bedroom on the third floor. Oh my God.
Go ahead with your. You're not under oath, sir, so no, you can't. I closed the public hearing, so this was just a clarification, so. We're done, Mr. Fetchner, thank you. Mr. Silvera, if you can repeat your motion.
All right. Wait a minute. I gotta get my train of thought back here for 1 second. Here, okay. I make a motion that we approve the petition with the condition that it has 3 bedrooms on the second floor and 1 bedroom on the third floor and 1 bathroom on the third floor, as was testified. If that won't work, then I'm sorry. That's what was testified. So that's my condition there, and eliminate of the rooftop deck.
Do I have a second?
I'll second.
Curtin seconded. Discussion?
Mr. Chairman, can you hear me?
Mr. Angelo, can you
Yes,
shut off the
yes.
public hearing?
Yes,
Mr. Chairman, it's Steve Hutler.
I've closed the public hearing, Mr. Hutler. Oh, Steve, I'm sorry.
That's our guy.
Mr. Hutler, you're not a voting member tonight, so your discussion really has to be limited to the people that are voting.
Why am I not a voting member tonight? I've sat through the whole thing.
No, the voting members this evening are myself, I'm sorry, it's myself, Mr. Curtin, Mr. Heaney, and Judith.
Why? I'm here.
Yes, but you're an alternate, sir.
I'm not an alternate.
Oh, you're not? Then why, how come my board, I'm sorry, Mr. Hutler, that is my apologies. Go ahead and ask your question, or your discussion. We have to fix this, by the way.
I'm going to speak to the motion and express my opposition to the motion and say that I, as a voting member of the zoning board, am not persuaded that the petitioners have met the burden required by the zoning ordinance for the following reasons. First, I think the third floor deck, not the widow's walk, that's been eliminated, but the third floor deck is itself not the least relief required, because I think to achieve the goal that the petitioners listed of some additional living space for the family, this additional encroachment is not necessary. And secondly, I do believe that this is an additional encroachment into the setback because it extends above the second floor deck, which is itself an extension of the encroachment that was there at the time they purchased the house. Third, I think that that is the result of prior action by the petitioner. They did extend the second floor into the encroachment space, into the setback area, and now they're building over it by building another deck above it. Fourth, I'm not persuaded that they're not really doing this for financial gain. It may not be their current intention, but based on the past situation and the kind of second home nature, as opposed to it being their primary home and so on, I'm not persuaded that it's not being done for financial gain. And lastly, I agree with the testimony of Mr. Hool that given what has been presented, the utility has increased well beyond the additional square footage added, which suggests to me that it is not the least relief required. So for all of these reasons, I'm opposed to the petition, even with the conditions set forth by Mr. Silvera.
Okay, thank you, Mr. Hudler, and I apologize, I didn't realize that they had elevated you. I do apologize for that. A point of order, you don't need to object to the motion, just object to the petition. Other discussion, please, from the voting members tonight? Curtin, Mr.
Yeah, this is Tom Heaney, just so everybody knows who's speaking. I think as you look at the proposals that was made and the amendments that were agreed to by the petitioner, and looking closely at the conditions for variances, when it talks to hardship, we address the unique characteristics of the subject land, but we stopped our conversation there and we didn't read the rest of the statement, which says or structure. And that's exactly what we're talking about here. We're talking about the existing structure, and the proposal is to go up within the existing structure. So again, I think it does meet that condition of the variance, because the hardship comes with both the unique characteristics of both the land and the structure. And then not only that, as was already mentioned a couple of times, there is an existing deck on the back. They are not proposing to build over the existing deck on the back. They're proposing to build over the existing footprint of the structure, which again, based on my reading of this condition, is not a result of their prior action. So I'm supporting it because I think it meets that prerequisite for the hardship. And then lastly, when we talk about the general characteristics of the surrounding area, we've already seen, based on testimony from both sides, that in this vicinity specifically, that there are multiple three-story homes with very similar footprints and designs. So to say this doesn't fit it and the other ones do, I don't think it would be right. So for those reasons, I am supporting.
Thank you, Mr. Heaney. Mr. Silvera?
Well, it's a very difficult decision, and I believe there's been so many different, things that were testified today and conflicts, and I think that it's just not a valid petition, and I'm gonna vote against it, even though I put the conditions on it. That was just in case it passed.
The issue of variances under 903 is very difficult because the least relief necessary is so subjective and so arbitrary that it really comes down to, was there expert testimony put on the record to either support it or not support it? And my feeling is that the removal of the deck on the roof, that's great. So it's very difficult to, whether they need it or not. To answer everyone in the audience, the fact that there are other houses or properties in the area that have similar characteristics that may or may not be within the zoning code really shouldn't. The last thing they say is the fact that a use may be more profitable or that a structure may be more of a, I'm sorry, wrong one. Non-conforming use of neighboring land or structures in the same district and permitted use of lands or structures in an adjacent district shall not be considered in granting a use variance. So it comes down to, did they meet the standard? And I think with the amendment they did, but my vote is for it, but the total vote for and against, let me just take a roll call. Mr. Hudner, you're against it. Mr. Silva, you're against it. Mr. Miller's against it. Mr. Curtin? You're for it. Mr. Heaney's for it.
For it.
So the vote's 2 to 3, you're not voting tonight with Mr. Hudner's on. I didn't get the memo.
Not an alternate.
Mr. Costa, we really need to figure out who a voting member is and isn't, because I was just,
Normally, it's right on the back side of your green folder that you have everything in, but we'll
but
get
right
that.
now, I know Mr. Curtin's a sitting member, I know Mr. Heaney is, I know I am, and I know Mr. Silvera is. And then Mr. Hudner was made a sitting member at the last council meeting, so those are our 5 sitting members.
There are 5 seating members.
Thank you. We need to get that out in a memo so that we know.
I will get everybody out tomorrow.
So I apologize, Judith.
I
That-
was, okay, I was, and now I'm not.
I don't know, that's the council's business.
Okay.
So the petition fails on a vote of 2 to 3. And thank you. We're going to take, Mr. Costa, we are at the end of our 3 hours.
What's your pleasure, Mr. Chairman?
You guys want to hear the next?
I'll take a break.
Yeah, we're going to take a 5-minute recess and we'll hear the next petition. I don't think we'll reach anything after that one. I think that will be our next and final petition. So everyone else, you're invited to that alternate meeting that we planned in the beginning.
On the 8th.
On the 8th of February. Everything's continued until the 5th, 8th. Call the meeting back to order. Mr. Heaney, can you read the next case?
Petition of Seamus Kirby, owner, by their attorney, Jeremiah C. Lynch III, Esquire, for a variance from sections 603 to construct a cupola. The proposed cupola's height is 39 feet 6 inches, where 35 feet is permitted. Said real estate is located at 24 Walcott Avenue and further identified as Lot 4 on Tax Assessor's Plat 121 Northwest.
Good evening, Mr. Lynch.
Good evening, Mr. Chairman, members of the board. Jay Lynch from Orver, Ganamo, and Lynch on behalf of the owner and the applicant. I have 3 witnesses this evening. I'll try to move it along based upon the lateness of the hour. I have Mr. Kirby, the owner, who will testify, Jacob Trent, the designer of the house, and I also have Mr. Hool to give expert testimony. Just to give you a brief overview of the relief that we're looking for. This was a previously approved house, a building permit. During the course of construction, the owner thought it would be aesthetically and architecturally pleasing to break up the roof line and add a cupola to the house. The owner looked at the height requirements and initially thought that the cupola is exempt under the definition of height as a spire, chimney, flagpole, or the like. So they started construction, and Mr. Costa advised them that based upon the size of the structure, we would need a dimensional variance for a height variance for the cupola based upon its width and height. So we filed the appropriate request for relief, and we're here tonight asking for the 4.5-foot height variance for the cupola. Just to give you some background, this is not going to be habitable space. It's just an architectural feature. It's not accessible easily from the interior of the house. You'd have to climb up through a hole in the second-floor ceiling, crawl through the attic to get to the site to change light bulbs, whatever the case may be in the structure. So it's not habitable space. So with that being said, I guess we'll call my first witness, Mr. Kirby, Seamus Kirby.
How you doing, board?
Raise your right hand, please. Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
Seamus Kirby, 24 Walcott.
Okay, thank you.
So initially when I started building at 24 Walcott, we had our lot coverage laid out for the house. And I was kind of designing on the fly to be aesthetically pleasing to kind of how I felt it should look and fit in with the neighborhood. And throughout history, my family's been a pretty big part of just that area in general. My grandfather used to own 298 Prospect, and my great aunt used to own 294. My dad and aunts and uncles grew up at 298. My great-great-grandfather's old farmland was where 24 Walcott is. So with that in mind, I tried to keep in the architectural aspects of said building to be somewhat of a coastal farmhouse. So once I finished putting all the trusses on, getting the roof together, I figured something was missing, and I thought it was cupola. And under current zoning codes, I mean, Mr. Costin, correct me if I'm wrong, but there was no indication of a size specification, whether big or small, of what a cupola was actually limited to be. So what we went ahead and did is actually just proportionally design it to the size of the house that wouldn't make it look awkward or out of place. And any bigger it would look bad, and any smaller I think it would look bad as well. So we went with the size that we have now, and then Mr. Costa showed up and said we had to come here, so no problem with that. That's all.
Now you're asking for 4.5 feet height. If you built it any smaller, any lower, how would
It would look completely unproportional. It wouldn't look right sitting on top. It just wouldn't. You know, you're going for something of a lighthouse sort of look, and a lighthouse is supposed to, you know, protrude upwards and kind of be a a little bit above other height areas, but, so you can see a light, and that's the aesthetic we were going for. But any smaller, it wouldn't look right, but also any bigger, it wouldn't look right. It was just proportional to what we had.
Explain to the board whether this is habitable space.
This is the hardest possible place to get to in the entire house. You have to, our whole roof system was a trussed roof system. I installed it myself, and it is not an easy task to get there. You gotta be somewhat of an athlete to get up in there.
Just explain to the board how you'd access to change a light bulb.
Once we're done with the house, to get there, I'd have to deconstruct a closet, take all the shelves out, go get a ladder out of the garage, climb up, push a panel out of the ceiling into the attic, get up into the attic, climb through there, pull the ladder up with me, put the ladder up to the entrance of another panel that would go into the cupola, push that panel out, and squeeze through a 16 by 2 foot hole to get up there to change a light bulb. I don't think it would be quite possible for me to occupy that space.
So I agree with you that it would look improportional, but it wasn't, the cupola was not a part of your original plan that you approved on.
Initially it wasn't.
No, so.
But just my understanding of the code was that it was treated as if it wasn't an aspect of your height restriction, so that's how I took it. And
But a roof would be, right?
A roof, yeah, but a roof is also a part of like livable space.
A roof, so the attic that you just described that you had to crawl through, that's not livable space either though, right?
Well, in a sense, you could store stuff up there, I guess. I don't know how you consider an attic.
I mean, our issue is really like you applied for variances, you were granted variances to build a plan, right?
Yeah.
And many of your neighbors didn't even want that, right? They thought it was too big for what it was. And then the plan changed, and you decided to do something on your own, you know, and built this cupola larger than what it should have been without, like, we've all seen it, we've driven by, it's sitting out there, we know you've already paid for it, you know, we know, you know, like, you know, so there's a real issue that, like, it appears as if you just kind of just chose to do what you want rather than what you were, you know,
I just read the
awarded
Middletown
through
zoning
variance
codes.
from the zoning board already.
Well, I'm here doing this. I was just thought because of the zoning code that it applied to what a cupola is set as, which it doesn't apply to your height restriction.
Cupola doesn't apply to your height restriction, then
Referenced as an exemption. Under the new code, or is it under the new code? Previously it had been.
Under the current code, the building official, Mr. Costa, has made the determination that this is not a structure that is exempt from the height limitation, like a chimney or a flagpole.
Okay.
And as a result, it requires a height variance. So, and that has been the determination of the building official. That's why they're applying for the height variance. And I think what the board should do is to focus on the variance requests under the variance standards, and as opposed to necessarily how we got here.
But part of the issue is how we got here. And I'm going to Mr. Curtin's point, Mr. Regan,
Okay.
if I may, to Mr. Curtin's point, it wasn't in the original plan. You went ahead and you built it. If you go back, if you go and look at the roof like I did over 2 months ago, it's all set up to put that up on that roof. It would be up on that roof today had Mr. Costa not come by and given you a cease and desist. That's why you're here tonight. Not because you did it voluntarily, because you have to be here tonight. Because had he not gone by there, that cupola would be on that roof today. And what would you be doing? You'd be here begging for forgiveness, is what you would be doing. That's the point,
Mr. Chairman,
Mr. Regan.
Mr. Chairman?
Regan?
Well, I just want to point out to the board, just to make sure that everyone's aware of what we're doing tonight, is this is not an enforcement action. This is a zoning variance request, and it needs to be reviewed under the standards set forth in the zoning code. And any issues with regard to enforcement, permitting, et cetera, that's a separate matter for the building official to deal with.
That's correct. So we're here for a simple variance, dimensional variance.
Yes.
Is it, when did the code change?
That,
Definition of cupola?
the building height?
What,
Yeah, there's been a number of changes to that code, most recently with regard to flood houses and buildings in the floodplain, but it was probably within about, I'd say, the last 5 to 7 years.
About 5 years ago, cupola was explicitly referenced as an exception from height. It's not in this latest. Out the phrase cupola, put it in place, or, you know, spire, chimney, flagpole, or the like.
And I would assume that since it's not mentioned in terms of a cupola for height, there's no guidance given for the cupola in terms of its overall dimension. Because when you're looking at it on the design from every different angle, it is obviously, you know, protruding from the structure. So to say that we're just looking at it because of we're asking for 4.5 feet, because there's a lack of definition in the code, it just looks like, to me, like, to use an example, like you said, a chimney would be maybe that height, but it would be a lot less obtrusive than what we see sitting on the top of that structure.
Once again, this is a variance, we're not dealing with the issue of the definition. That's Mr. Costa's job. He has determined that this is not exempt from the height definition. They could have, I guess, appealed that decision and took an appeal to this board. They didn't do that. They instead filed a petition for a variance. So that's where we are. It's the variance issue and the variance standards.
We're not disputing Mr. Costa's interpretation. I think what we just tried to point out is from the owner and the applicant's position is that there was nothing in the code to guide him, hey, what you're proposing for a cupola. Costa's looked at it, and his interpretation is not an exempt structure, so he asked the file relief, and we have.
Any questions from Seamus? You have an expert witness, Mr.?
I do have Jacob Trent, who's a designer. He's going to just walk through very quickly and just walk you through as to what happened during the design.
Okay, thank you. Raise your right hand, please. Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
Jacob Trent, 28 Bennett Road in Ballintown, Connecticut.
Okay.
Jacob, you're the designer for this house?
Correct.
And you work with Seamus to prepare the plans for the proposed structure?
Correct.
Can you just state for the board the circumstances surrounding the change of the original design without a cupola to the what's been proposed now?
So when the structure started getting put up, we looked at the fact that we have a run of 42 feet and a run of about 50 feet. That is just a bunch of blank space above the dormers. So me and the client discussed putting a cupola up there to help break up the monotony of the ridges. Originally, we were going to put it on the corner of the house. Structurally, that was not feasible, so we did move the cupola over to its new location. and that is where it ended up.
Research before you.
Yes, so we, as a company, we have done many cupolas on houses. Usually, most of the time, they are above the height restrictions of the area. It is common for us to put a cupola on there as a decorative piece, and usually we do consider it equal to a chimney.
Do you have an opinion as to the requested size and height of this cupola? Is that appropriate for a structure of that size?
I do believe it is. I mean, the house is rather large and elongated, so the cupola, I think, fits the overall width of the house.
I think you heard Mr. Kirby minimum variance necessary to make this aesthetically pleasing architectural.
Yes, so when we originally designed it, we were designing it bottom up, and the reason that the roof line had actually made it over the 35 feet is as we were designing it proportionally, it raised up. The only thing going over the max limit is the tin roof. That's the only thing that makes it over that point, and so that ended up being the necessary to the design.
About whether or not this space that's created by the cupola, whether that's going to be habitable space or not.
So this is a very difficult area to get to. So it is a typical attic access with a push-up piece of plywood that is above multiple linen shelves inside a closet. So to get access to that, you would have to take out the linen shelves, push the piece up, get yourself a ladder to access that point. And then, as the client said, be able to bring that ladder up through the trusses, which would be difficult, bring it over to the point and access that cupola. I don't think it would be, it's a very inhabitable area.
Questions for this? Thank you.
So I think I understood you correctly, but just want to make sure. As the designer, you're saying that in terms of the cupola's height and width is what they are being recommended because of the overall volume of the home and the length of the roof lines.
Yes.
All right, thank you.
Mr. Jewell, you're already sworn in tonight,
Okay.
so.
All right.
Mr. Hull's report had been previously submitted.
Yes.
You know, one thing I'd like to say really before I get into discussing my findings, to Mr. Haney's point, you know, we've all driven by this and it's been on the ground, but when this is actually lifted into place, it actually will, and I think the architect would agree that the impact of it is going to be mitigated tremendously because of the overall relationship of the size and where it'll be placed on the building. But I, following what Mr. Regan was saying, looked at it strictly in terms of the criteria for the height variance that's being requested. And really, when you look at it, the code where it states spires, chimneys, flagpoles, and the like, it really doesn't give, as you've already alluded in comments, it doesn't really give any dimensional, you know, there is no dimensional criteria or guidance as to what the like would be in terms of size or scale or anything else along that line. So I think that when you look at the hardship due to the unique characteristics of the land or the building, I think that the building part, the hardship is actually the characteristic of the interpretation and the of the cupola itself, okay? I think that because there is no particular guidance, it creates that hardship that if you interpret it, that it's an architectural feature similar to spires or anything else along that line, that it would be sort of natural to be able to put the cupola on top, which is a common architectural element. The hardship is not the result of the prior action. Again, that sort of dovetails into the whole thing, that the prior action is the interpretation of the code and the fact that it doesn't give particular guidance to it. So it creates a problem of misunderstanding as to actually what it would be. And I don't blame Mr. Costa, because if you look at it, it is large and it could easily be mixed up with living area or an access that you might want to spend time sitting in, but as has been testified, it's almost impossible to get to it. It's very difficult. It really is just an architectural feature. I looked at it. The granting of the variance will not alter the general character of the surrounding area. I don't see it really having any negative impact. The house is there. It's in scale to the house, and it's only a single-family house. I don't believe that it really will create any imbalance or negative impact to the general characteristics in the neighborhood. And maybe it'll actually allow some better definition within the zoning code. So I don't think that it negatively impacts the zoning code. It may ultimately positively impact it. For that, the relief to be granted is the least relief necessary. It is only a 4.5 feet, 4.5 feet above the roof line itself is well below the 35-foot limit, so that it is only that one small area that will be going above the height limit. I think that it is the least relief necessary for that reason. And there's evidence to show the hardship would be more than a mere inconvenience. It is a design element to really a custom-built house that is very attractive, and I think that it would be more than a mere inconvenience for that reason.
Okay, any questions for Mr. Hool?
That the applicant rests.
Okay. Is there anyone in the audience that would like to speak for or against? Please approach the podium. Raise your right hand. Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
Karen Barbera, 36 Walcott Avenue.
Okay, go ahead, Ms. Barbera.
First of all, I want to say this is not personal to Seamus. We have a very tight little neighborhood. We all like each other. We all get along. We all tell each other what's going on. So this could have been avoided, or some of the animosity that's been growing here could have been avoided if Seamus had come to us and said, this is what I'm doing, this is why I'm doing it. So what I was going to say, and what I'm still going to say, was that, and I am a designer myself, so it's subjective as to whether that part of the building or that this new piece of the building is oversized. My personal feeling is that it makes me feel like it is very much oversized. I personally think it's more of a pergola than a cupola. And it looks like you could put a nice little party of 6 up there if you really wanted to. You can definitely see, without a doubt, the beach, the bridge, the whole thing. So, of course, we were definitely thinking that's what they were going to do with this. Whether you could change the interior of a building afterwards, you sure could. So that's what I'm thinking. So now, if we're not going to have that be public space above the code, above the variance, above the ordinance, then I'm thinking that that's going to be shining light in a very odd way onto the neighborhood. And that bothers me equally. I like my dark sky, and I like it nice and quiet. I like to see my stars. So I feel like that additional aspect of light up there in a very big way would impact the neighborhood. I don't believe that this house in particular fits in with the neighborhood. All the rest of our homes are smallish, very appropriate to the neighborhood. I feel like they have built a very large, very complicated building, and to put this structure, which Seamus himself said was an afterthought, I feel like it's very inappropriate. I think it's just like too much. So that's my personal opinion, but I'm saying all of this is subjective anyway, as to whether it's in scale with the building. So I don't know whether, you know, my first process was, what's the function of it? And then what are the consequences of that function? And the consequences are that we all feel that we are being intruded upon, and that our quality of life is been disruptive. That whole building site is very disruptive. But that's his right, that is their right, they own the property, they can do what they want in that respect, and we just have to wait it out. But as far as this cupola, which is really a gazebo in my mind, I just feel like this is just too much. So, thank you.
Thank you. Come on up. Raise your right hand. Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
Adelino Machado, 25 Walcott Avenue, Middletown, Rhode Island.
Okay.
I thank you for stopping the job. That's very, very important. If they were allowed to do something like that, and even though Seamus says it's going to have a little hole, I can't go upstairs, that's today. If they broke the rules before, and they're contractors, and they said, I'm just going to build this, what's stopping them from putting a ladder up there? Because it's big enough to have a party of 6 up there. They're going to be looking right at my bedroom and right at my bathroom. It's a clear view. I'm right in front of them. It's just not right. I mean, our privacy is for everybody, and we don't want to take anything away from anybody, but they just do what they want. As Mr. Costa said, stop and desist. If we don't do this now, 2 years from now, 6 months from now, they can put a ladder up there. They're contractors. It doesn't take much to put a ladder up there. And they go up there and they can just look over the neighborhood, or a light shine into everybody. It's just not right. The house is humongous already. Adding another 4.5 feet, it's just going to kill us. It's coming right at us, especially if we're in a bathroom, like I said, or in a bedroom. They can look right in. They can say they're not doing that today. Who knows what happens tomorrow, or 6 months, or 6 years from now? They're contractors. They should know the rules. They should have had the plans ahead of time and said, hey, this is what we're doing. But they do everything that they want, and that's not right. And I apologize. I'm a little nervous, so that's all I have to say. Thank you.
Anyone else? Jack, come on up. Raise your right hand, please. Do you swear the testimony this evening will be the whole truth and nothing but the truth?
I do.
State your name and address for the record.
John Turlesner, 32 Walcott Avenue. Again, can't iterate more what the others already said. Probably one thing I was trying to look up, what is the definition of a cupola? And some definitions I found is something that is a little decorative, but not much. They're not very big. They're to let light and air into a building, originally designed. What's the thing on top of this building? There's a small cupola sitting on top of a clock. I have not seen any other cupolas in my area except on top of a barn or on a house. Nothing this large, or exceeding those height limits. So that is the one thing we're all looking at. Is it extending the height limit? Yes. Should have been something that looked at before? Yes. Was it looked at now? No. So my argument is, you're looking at something that has exceeded the height limit It's after the fact. This place has already gone through a couple of variances already, one approved, one not approved. The place is large. I do have a hard time with the definition that it's trying to fit in the local neighborhood. When you look at the local neighborhood, the neighborhood is not that large. I would think that the cupola like this would be better off served down on Tuckerman Avenue by where that other place where the guy wants to put up a third story. But, oh, it's said there. But yeah, what is to say, talked about, hey, it could be storage up there, but it is accessible. Things can change over time. Once the walls are closed, once you move in, you can change anything you want without anybody knowing unless somebody says something later on. Other than that, that's all I have to say at this time. Thank you.
Thank you, Jack. Sure.
Again, I am nervous, and I apologize. But what I see is that somebody's going to put a ladder up there, because it's very easy to do, you know, and they can just go out there and just look all over the neighborhood, the bridge, the water. Not my concern, but right into my house, that's a concern. That's a quality of life. They're going to be able to look right into us. And again, I'm not saying that Seamus is going to do that today, tomorrow, but they're contractors. They can do anything. And if they sell the house, the next person that's going to come, oh my God, look what they got. We can look all over the neighborhood. That's just bad.
Okay, thank you.
Thank you.
Is there anyone else in the audience that would like to speak either for or against the petition? Seeing none, I'm going to close the public hearing. I didn't see any hands go up on the board, so we're going to close the public hearing. Jay?
Wrap up, I'll be
Sure.
very brief. I spoke to my client, we've heard the concerns of the neighbors about privacy issues and light pollution, et cetera. We are happy to impose a condition on the approval, if this board is so inclined to give us approval, that this area, this cupola, gazebo, whatever you want to call it, shall not be habitable space in the future, from today in the future. So we're agreeable to that condition. We are also agreeable that there'll be no light impacting adjacent properties. There's only going to be one light bulb screwed into the ceiling. It's not going to be the lighthouse up there. It's just going to have a light inside. We're agreeable to condition that there no light will be onto adjacent properties. What we have here is clearly, this is a situation that was fluid as they went during construction. They decided to add an architectural feature. Hindsight's 2020, we should have come in to Mr. Costa beforehand and asked for a variance at that point. We're here now. We spelled out why there was some confusion about why we didn't seek relief initially, but we're here. Again, it's a 4.5-foot variance for an architectural feature that is not going to be habitable today, tomorrow, or forever. My client respects the neighbor's privacy. He's not going to be up there. He's not going to be shining lights onto the neighbor's property. He's not going to be looking in the backyard. So if the board is so inclined, would be willing to accept those conditions.
Thank you. Can I entertain a motion with those two conditions?
I'll make a motion to accept the petition with the two conditions. One, that the that the area not be habitable, and two, that the light will not shine on the neighboring property.
Do I have a second?
I'll second.
Discussion?
I'm happy to go first again if you'd like, Mr. Chairman.
Lead off, Mr. Hudler.
Okay. I am also opposed to this petition. I feel not, the petitioner has not met the burden of the zoning ordinance. I don't think that habitability is the principal concern to me, whether it falls into the definition of spire, chimney, flagpole, and the like. I think it's fairly massive or relatively massive size. That is what's relevant here. And given its size and scale, it could not reasonably have been thought to fall within the definition of a spire, chimney, flagpole, or the or the like. I do believe it would alter the general character of the neighborhood, having something this big over the 35-foot height limit. I do think the height limit is a very, very sensitive topic in this part of Middletown. And I think allowing something this massive over the 35-foot height limit would alter the general characteristic of the land. And all of this hardship has been created by the applicant. Lastly, I would say that if we ever come across a case where mere convenience is relevant, I think this would be that case. It's obviously a subjective term and subjective to the petitioner, because what's convenient to someone might be burden to someone else. But being deprived of the right to have this structure on this property over the height limit, to me, is not an unduly burdensome situation for the petitioner, and is as close to a mere inconvenience as I can think of. So I am opposed to the petition.
Thank you, Mr. Adler. Further discussion?
Excuse me, I'm also, this is Tom Heaney speaking. I'm also going to echo my colleague's disapproval of this petition. He's covered really 4 of the 5 points in the variance that I think were applicable. And I agree with that perspective. And I don't agree that this hardship wasn't the result of any prior action. I think it definitely was. And I think because of the character and nature of the size of this cupola and the height of the cupola, that it will alter the general characteristics of the surrounding area.
Any other discussion? My feeling is the code is silent on these accessory structures, you know, architectural details. And in the absence of that, I think we have to rely on the code. So I too am going to have to echo the prior 2 gentlemen, because with the absence of specific language to deal with this, then we're left to going with the section 903. And I too echo that I don't think they've met the standard. So with that, vote, all those in favor? All those opposed?
Aye.
It is not approved, 0 to 5. With that, I'm going to close the hearing tonight. I thank you all. Can I have a motion to close the meeting?
I'll make the motion to adjourn.
Motion made by Mr. Silvera. Do I have a second?
I'll second.